and then she just added another phone number to the 13-year-old grandson who's possibly with the daughter. Step out with this.
2412.
Veteran crisis hotline's calling in, so they have a female veteran off her medication. She's at work to St. David. Detective 12, check that one out. Also still saying for talking, no? Offender in custody. Anyone else close might just rest on, let me know. Phone number to the 13-year-old grandson who's possibly with the daughter. Detective 12, check that one out.
2 points, start taking shots.
What's up, everybody? Thank you for joining us this evening. We're going to be having a power panel tonight. Special guests this evening will be dropping their links throughout the show, so you could definitely go sub to them too. Beautiful content creators out there joining us for the show tonight. I want to say thank you. Thank you to everybody for hopping in this evening. We're going to be having an extended show tonight. The guests are more than welcome to hang out as long as they'd like. And we're going to be going through the review of yesterday's court hearing. We're going to be kind of giving our thoughts, going over it again, reviewing it, and just a collective amount of thoughts, from different perspectives. I think it's going to be very interesting to hear it all at the same time. And then towards the end of the show, we'll be going through whatever for the case, general talk. So thank you all for hanging out. Appreciate you. Go ahead and say hello, and then I'm going to introduce all of our guests this evening. I'm so excited and thank them for their time this evening. I really appreciate it. It means a lot to us and the community. Katrina Miller, ticket number 5. Kelly, ticket number 6. Kib Kitty, ticket number 7. Danny, number 9. What's up, Kelly? Good evening. How are you? Good to see you. Katrina. Ashley, yep, we got Tommy tonight. We got a whole bunch. I'll be dropping their links throughout the show, too. Lynn T, ticket number 14. Yoli, ticket number 17. Ohio, Breaker, ticket number 19. 49er Girl, ticket 18. 19, maybe? I don't know. We'll see. Iris, ticket number 20. What's up, Sweet Surrender? Mary Golden, ticket number 23. What's up, Steve W? Ticket number 28. D. Marie, 24. With the hello, thank you. Appreciate that. Thank you, Tommy Jude. Melissa, number 34. Thank you very much. Good Vibes, number 32. Thank you for hopping in. Diana, number 3. Ooh, number 3. Nice. Appreciate that very much. Let me see here. I don't want to miss anybody. Natural Healing, good evening. Echo, ticket number 33. That is golden. Appreciate that. What's up? Collateral Damage, how are you? There's Forensic Frenzy. What's up, Rock Chalk? Charlie Brown, Mama, ticket number 30. Thank you so much, Echo Contribution Call Out. Thank you so much for the gifted membership. And it was Natural Healing. Awesome. Thank you so much. Appreciate that. Moonlight Rays, ticket number 40. Thank you. All right. I'm going to go ahead and do the switcheroo real quick, and then we'll bring up our guests. And this is going to be fun. I can't wait. Thank you all for showing up. Please hit the like if you haven't yet. It is the free way. And don't forget to sub to all these guests. Appreciate it. Here we go, everybody. Good evening. Good evening. How are you all? There we go. What's up? How is everybody? Let me turn this music down just a skosh here.
Hey, CJ.
What is up? How is everybody? How are you all? Thank you all for hopping in. I really
Doing good.
Hey, CJ. Hey, everybody.
What's up?
Howdy there, CJ.
Good. How are you? Let me see if I can fix this. There we go.
Hi, Tommy. Nice to see you guys.
Good to see you, Forensic. And who else do we got? And always good to see Mr. Myers over there.
Nice to see you.
Hey, dude.
Yes,
I was like one of your first subs. I think you had
Very nice to see Mr. Myers.
Thank you. Thank you. Yeah, Forensic, we love your stuff. We love your stuff. We watch it all the time.
yes,
Yep.
yes. Awesome stuff.
Oh, thank you. Thank you. I love your stuff.
Thank you.
And let me go ahead and drop all their links
Good
here.
evening.
I'm gonna drop them one at a time. And I wanted to ask you guys, first of all, how many of you were able to watch the court hearing yesterday?
Yes.
Most of it.
Most of it. What about you, Tommy?
I did.
Yeah,
Forensic,
I watched the whole thing. I actually aired it twice.
Oh, really? Okay. I mean, I did it. I did
Yeah.
it during a live, and then I just made it its own video. That way, nobody had to watch the whole live.
That's
It was
what I did it live, and then I watched my own did my own show twice.
yeah.
They took it down so fast,
Yeah, I mean, as soon as it was over, it was gone, so it's a
Right.
good thing that we were all, what's up, Sue? It was a good thing we were all able to document it because I thought it was very important. I thought there was a lot of key things in that court hearing, to me, in my opinion. So I'm going to ask each of you what your top two, what you think, if you would like to. I'll start off since Forensic is right next to me. I'll go ahead and start off with you. Did you have a top two of wow moments or something that you thought was just really interesting that maybe caught you off guard about the court hearing?
I do.
Okay.
I do. Okay, so I am totally taken aback by the fact that while the prosecution feels like they have a full enough case to prosecute the defendant as of like this coming summer, Anne feels like she has absolutely nothing. I was taken aback by the video that she mentioned, especially the way that she spoke about it. And I think that another notable thing is just that she mentioned going back into like his family tree herself, and that being an American Bar Association like standard for a death penalty case. So I feel like there was some things that they knew they were going to have to align with one another on at some point. And it's weird because those are the things that they don't seem to be aligning with one another on.
Yeah, it's interesting you said that you mentioned that prosecution was so ready to have a trial in 2024. And towards the end of the court hearing, you hear Ann Taylor even say, I'm nervous telling you, Judge, that we would even be ready by the summer of 2025 based off of everything that they don't have or that they're not getting. What about you, Andrew? What were the top couple wow moments to you?
Okay, I'll fishtail off of something Forensic just said, and that is that Ann Taylor pointed out, all the work that she still needs to do going forward. And she pointed out that if she were forced to go to trial any sooner then maybe March of 2025, a year and a couple of months away, it would be ineffective assistance of counsel. And that is a legal buzzword. That is a legal buzzword. If you lose, if you're a criminal defendant and you lose, that is one of the primary means for appeal, that you had ineffective assistance of counsel. And so she said that several times. She said it a couple of times. And so that you could see the judge shaking his head, and he kind of, he was taken aback by that, because I think he wants to get her done as quick as he can.
Well, I mean, yeah, of course. But Ann Taylor was even saying that the photos that she has from LE that's in the crime sheet, she don't even know what date or time those photos were even taking place. You know what I mean?
Okay, that's number two. That's number two for me. But CJ, how can she not know when or where the photos were taken? Because now, in the last 10, 15, 18 years, photographs taken by a digital camera have a footprint, and you just go into the properties and you see when and where they were taken. So I didn't understand that. But I'll fishtail off of that too, because what Ann Taylor said, and I'm looking at my notes because I want to get it right, she has received 250 items in discovery, 13,000 photographs, police reports. We haven't seen a police report, as far as I know. Photographs,
no reports taken.
Video. Well, she says in her list of 250 items in discovery that police reports, photographs, videos, interviews, and none of them are indexed. So how in the world do you go through that volume of stuff if it's not indexed? So those are two of them.
Especially from 3 different agencies, that are wanting to talk to one another, supposedly. Very good. What about you, Silky? Did you have a couple from the court hearing that maybe you'd want to?
Yeah, no, well, because I didn't get through all of it, I don't have as much, but I compare, because, I've been lost in Delphi. I compare everything, because Kohberger was arrested about 2 months, right around 2 months after Richard Allen. And, the original attorneys, had we not had this whole fiasco, were ready to go to trial this month. Like, the trial should be taking place now. So that was the thing for me, is 2025 and all of this, like Mr. Myers said, all of this undiscovered and, stuff that she hasn't been able to go through. I'm like, wow. Is it just, and I'm a little confused and a little dense maybe in this case, but is it just because she didn't have it and now she's just received it and has to go through it?
I mean, no. When you listen to her towards the end, she even talks about all the video and even the cast data. She doesn't even have the cast data.
Wow.
This is stuff that should have already been available, in my opinion, when you arrested somebody on January or December 30th, 2022.
Right.
You don't have the cast data still. This is past all the IGG stuff. She even said in the court hearing she's still waiting on the IGG stuff. But beyond all of that, the video, she said, when I look at the probable cause and I'm going over it over and over, I still can't see how the prosecution, I still can't see how they even got to BK. And this is Ann Taylor going, the technical wizard. So and then she also describes a lot of the information that they're getting is scattered, just like the PCA. If you read the PCA and you want to talk about certain sections, you literally have to cut out a paragraph and take that one and put it over here, because really this paragraph was really supposed to go here, but it's down here. I mean, so I'm sure all the documents are going to be like that, and they probably don't care, because that's just more work that the defense has to go through.
Sure.
They could have had it all in order And correct me if I'm wrong, Mr. Myers. They could have literally had all that stuff in order, threw it in a box in whatever order they wanted it into, and that's perfectly fine, right?
Sure, why not? Yeah, why?
Yeah.
I mean, they have all this other stuff that's not indexed. Why can't they put the cast in?
Right.
And I don't buy this. I was going to use a bad word. I don't buy this stuff about, oh, well, there are 3 agencies. So what? These agencies, like the FBI, we won't even get into that, but agencies like the FBI have tons and tons and tons of money. And you go into the Boston Bureau of the FBI, and there are literally, scores of people sitting around playing on their computer, reading the Boston Herald, just doing whatever they do. They have plenty of people that can tie all this stuff together. It's as though, the Idaho4, it's not that important. No, I don't buy this BS about, oh, it's 3 other agencies. Nuh-uh. Get them together, make them work, make them look at the stuff. They could get it all done in a week if they had to. I don't buy it. I'm sorry. No.
No, 100. I mean, they should, because it's about the victims. Do you have any more, Silky? Do you have one more that you thought was like crazy?
Not really, because again, everything seems way more sane. I hate to say that, but it seems way more sane to me, even with all the aberrations, than Delphi does, because that's a crapshoot. So I mean, to me, it is listening. Of course, not on the scale of Lisk, but better than what I'm used to.
Well, and there's another one that's starting up too, Kansas City 3.
Yeah, I'm gonna dive into that one too. Yeah.
I have a feeling we'll be doing a show tomorrow night. It looks like that's what the community's voting. We'll be doing a social on that. So, and if any of you would like to join tomorrow night as well, you're more than welcome. Same time. Tommy, what about you? Is there what 2 wow moments caught you off guard?
I think it's all kind of wild.
Yeah,
I just it convinced me that LE really doesn't have a strong case. That's my opinion. I think that a lot of these delay tactics are because they don't have a strong case, and I don't think what's mentioned in the PCA shows that they have a strong case. All it did is verify that for me.
Yeah,
that's all it did. And I kind of like the way Anne went about it. I think she was a little stronger than she has been. I think she made some really good points. I could tell by who was the gal that was in the left hand down below on the left hand side.
Ashley Jennings. She's an assistant to Bill Thompson.
She had some really peculiar looks during that I was watching.
Oh, it was very interesting. Like when I was watching it, you could tell she was responding to somebody that she was typing to on her computer and it's like, wow.
Right. And she had a kind of a freaky look a few times. Like, I don't know. What I took from it is that they just don't have a strong case. And that's why they're all these, they're not getting stuff to them. And like Mr. Myers said, that Andrew said is, they could have this done in a week. Well, it's been how many months? It's been over a year.
Yeah. Well, and when I was watching it yesterday, I'm sitting there going, and it's obvious from what she almost unsealed stuff herself is how I felt it, because we didn't know that, she was still waiting on the videos to show.
Right.
We didn't know she was still waiting on the cast.
In my room, when I was running it live,
no time.
I mean, it was like everybody was like, yes, because it was finally getting open, out in the open. It was finally getting out in the open that all this stuff is going on, and she's not getting anything.
Right. Exactly.
And, I mean, we've heard it, but to say it in front of the judge and to say it the way she did, I thought it was pretty good. I thought it was good.
I got a question for y'all, because this is the conclusion that after that court hearing, I want to ask each one of you guys what you think of this conclusion after the court hearing from yesterday. I have the conclusion, and I kind of always felt this way, but after hearing what Ann Taylor still needs and how and the stuff that she's gotten and how she's gotten it and the stuff that she has to do that shouldn't even have to be done, it leads me to believe, and I always felt that they didn't get on to BK until the end of December. That's just my opinion. Just a couple days before the whole DNA stuff, just days before the DNA match with Daddy. I feel after the Oregon car went bust, how they set up a team, they all traveled out there, they were gung-ho, they were excited, they went out to Oregon, they found out that the Oregon car was a bust, they were all depressed, crap, we got enrollment coming up in less than a month. Then all of a sudden they got a tip, which is what I've always been saying, they just wanted the tip. They're just going to use the tip, and I have a feeling after they got that tip, they were anticipating that all of this evidence was going to materialize in time. And unfortunately, what happened is they jumped the gun too quick on arresting somebody, and the evidence never did materialize, and that's why we're sitting here where we're sitting. What do you guys?
I actually got somebody that a pretty good inside information on that. They had his name as far back as November 15th.
Oh no. I'm not saying they didn't have it. No. What I'm saying is no. They had a lot of tips. They had a lot of tips with the Elantras.
Yeah, well,
they had
what
a lot
I heard
of
is
names.
they ran any cars that had been pulled over in the last year.
Yeah,
and he had been pulled over in August.
Yeah,
and they had his name from like the 15th.
Yeah. I'm not disputing that at all. That's not what I'm saying. What I'm saying is they weren't going to. He was amongst a bunch of other people that were in the same situation. There was a bunch of other people that also drove, because if you remember, they weren't.
Well, yeah.
Even up until the 16th, Tommy, they still said 11 to 13. BK doesn't have one.
I don't know if that, even after they had his name and had him as a suspect, they were saying that.
Yeah, that's what I'm saying.
I think it was
amongst a pool of
I don't
people.
know.
That's what
Andrew,
I'm saying.
Get Andrew's take on that? I'd like to hear his take on that. Why would they do that?
I don't think.
I'd rather look forward and figure out what they're going to do from here on in. I mean, she said that she has these, and we already knew this, but she put it in context. 51 terabytes of information, and they don't have Kohberger? What?
Video.
Wait, what? Video. I mean,
right?
Huh?
Video.
No, they have. You keep saying video. No, they have 51 terabytes of information. That's equal to 250,000 photos, or 500 hours of H. What?
How much? Here, I got a perfect tweet to show you from Pretty.
A lot of that'll be video, though.
Yeah,
well,
right.
It's equal to that, or 6.5 million document pages. So my question is, if they have that much stuff, they don't have Kohberger? Really? How can that even be? I don't get that at all.
Yeah, that's right. There's something going on in Moscow. I'm just saying, man.
Well, our friend Scott Green,
and it's not just Ann trying to find Kohberger. It's actually herself and the experts that she's working with, and no one can figure out how they got to him. So that counts.
No,
yeah, it does count.
You're misunderstanding. I'm not saying that they didn't have Kohberger's name on November 28th. They did.
Yeah.
I'm not saying that. What I'm saying is he was still part of a collective pool. What I'm saying is he became separated from that collective pool at the end of December. Because if you go into their interviews from the beginning, they're talking about having to switch up the force because of holidays. That doesn't make sense. I think, to me, that's when you found out somebody fucked up that initially walked in the crime scene. But you look at the interviews later on, they're still not. They still say suspects. It's still plural, and they're still looking for a 2011 to 13. So I feel somewhere from mid-December to the end of December is where they were just,
but
shit,
they could
we
be
gotta
just saying that. They could be just saying, they could just be they could have had their eyes on Kohlberger long before and knew that they were going after him, and still
I think you're both right. I think you're both right. I think that they actually did obviously know about him well before. I think about December 15th is when they decided that he actually was a part of it. Yeah.
Right.
Yep.
Yeah. They separate him from the pool of all the other people because they had how many tips? Just in the white cars they had to comb through.
They got 9,000 new tips according to yesterday, right?
Yes, 9,000. Yeah.
Are you serious? Yesterday they got
9,000 new tips.
She said yesterday that on January 4th they received 9,000 new tips that closed out in October.
Oh, because they had to close. I've never heard of that before. Where you had
I guarantee you they're not Al Kohlberger at all.
Completely close out a tip line in order to collect the remaining tips. I don't understand.
Yeah, I think we're being hosed on a lot of this technology. I think we're really being hosed. I mean, since when do you have to close a file to get the information out of the file? It makes no sense. No.
I never heard of that. No. I never heard of that. No.
Another thing that doesn't make any sense is the video that she's got in pieces. So if they have the video and it's not in pieces and that's how they got to Kohlberger, then why can't the video be sent over to Anne all in one piece? Why is she getting bits and pieces that she has to puzzle back together?
And in addition to that,
they've already done the job for you.
And they said they had to match up the audio to the video. Why is it in pieces? Why wasn't it just one unified piece? We're getting hosed in the technology. Yeah, we're being hosed in the technology here. Either we're being hosed or they really, really, really don't know what they're doing. And
that's why
one is a possibility.
That's why I think they got the tip from FBI in the middle of December, ran with it, expecting the cast, expecting the video, expecting all of this stuff to materialize, all the stuff that Ann Taylor says should be there according to the probable cause affidavit, because that's what they stated. That's why I feel they don't.
Add to your statement.
Yeah,
it's all the stuff that they believed in the statements as well.
Right.
All the stuff that they believed. Yeah.
In order to arrest this gentleman, because I feel like if they didn't have the DNA match, they wouldn't have been able to apprehend him the way that they apprehended him. I don't think so. They would have had to bring him in. Period. And
that's another whole question: is why didn't they bring him in for questioning? This is
why'd you let him go from the country? You know
he should have been in. He should have been brought in and questioned, asked if he'd do a DNA test instead of making this big Hollywood
before he left
thing out in Pennsylvania.
Valid point.
Right before
he
left.
So that tells me that they didn't think for sure that he was a part of this before he left Pullman, because they wouldn't have let him leave.
Right, part of a pool, because the FBI to have a who knows, it could have been a child in his path if this person committed this crime.
Heard they lost
you know what I mean?
I think I have the answer to that one. I think I have the answer. I think that I hate to say this, but I think the Moscow Police Department wasn't equipped to do it. Either that or they didn't have the chutzpah to do it. The Pennsylvania State Police are serious dudes. I was born and raised in Pennsylvania. That's a together department. They don't take any guff from anyone. And I think that once he went to Pennsylvania, man, the Moscow police had an out. They wouldn't have to do anything dirty, get their hands dirty. And they said, hey, let's get him in Pennsylvania. And Pennsylvania police said, make my day.
Well,
I just don't think the Moscow police, really wanted to do anything.
Well, what's interesting too, piggybacking off what you're saying, what's interesting too is when you look into not only the Washington State PCA for the search, for the office and the home, and then also the PCA when it comes to the Pennsylvania PCA, right? They both state in their PCA, look, this is only because of what we were sent from Idaho in order to do what we're doing. And I think that's them even saying, look, we're covering our ass because we don't want to get in trouble because they sent us some bullshit information.
Right. Well, but at the same time, the FBI was involved. The FBI was behind the whole thing also. And so,
why couldn't you get trash from him?
What?
I think there was some arguing going on.
From BK? Why'd you have to get it from his dad? Why couldn't you get trash from BK?
I said that a long time ago.
Like
why
he didn't sip out of a cup? He didn't.
No, there's something funny. There's something going on.
Because they weren't on to him until he was already in Pennsylvania and apparently sorting out his trash by then. So.
I don't think the FBI and Moscow Police Department were getting along very well. I really don't think they were getting along.
I don't either. I don't either.
Because FBI was like, yo, y'all done fucked this shit up in the first place.
Right.
For whatever reason. That's
and then they had the nerve to go on TV and go, this is our investigation, and this is it's like, whoa.
Yeah, they're gonna have.
And that's how you know there was a problem because they even needed to clarify that. Who were they clarifying?
They should have they should have let the FBI do their job instead of chasing them away.
Yeah, and that's interesting. You have President Green up there instead of the FBI.
Oh God,
and really, like I feel like because really they knew, just like a lot of these small town corrupt. We see it in all these other.
And then they're having meetings. LE's having meetings with Scott Green. So and how to shine that university.
Shine that diamond. What they do is they know already, like, hey, if I request the FBI, I can keep them at bay from what I want them to assist us with because our britches are too big. So I think that's another reason why the FBI was frustrated, because they saw all the fumbaloos that took place from the beginning. They wanted to help, and they couldn't help because the Moscow PD didn't allow them to help because it was up to MPD of what they were wanting to help with. What do you think, Silky? Crazy shit.
Yeah, I was thinking about, you're saying how did they get to Coburger and, the big talking about fumbaloos, that thing when you crashed car. But, if like we talked a couple of weeks ago, if the testimony or whatever, the interview from the private driver, if that is true, he said he tipped it in and, he saw the car. And I'm just thinking, yes, I know they got a whole lot of tips from a whole lot of people, but he was already working there. He already had connections at the school. So I'm wondering if his ideas, his testimony, hey guys, I think I know who, this car belongs to. I wonder if that one held more weight, and that is maybe pointed them in the direction of Coburger.
Especially when your wife works for MPD.
Exactly.
Right.
I mean, you would think that it's credible. This is one thing that I just never understood is, it's always been the 1,200 feet from Coburger, my neighbor, but you never had a Pullman address. So I don't.
Yeah, that's crap to me. That's ridiculous.
So who knows? I don't know. Is that why there is a different spelling in the PCA where it does show the name? I don't know. We couldn't find anybody with that name for that area. Doesn't mean that nobody there didn't exist, but it's definitely odd.
And might have been a typo. They throw these things together so quickly.
I'm sure it was. I'm sure it was. I'm sure they did misspell it, and I'm sure we're talking about the right person. Which, then you go back to, well, then how were you 1,200 steps away and Coburger was your neighbor, and that's how you tipped it in? Because when I went there, I was in the parking lot. I'm sorry, you're not, and I even showed it with my footage. You're not driving by and going, oh gosh, there's a white Elantra over there. It's just not happening. It's not happening. So I don't know. It just doesn't make sense. And if you're helping out the University of Idaho drop off students, well, then you wouldn't be dropping off students at Steptoe Apartments, right? If you're living in Moscow and you're dropping off University of Idaho students as a volunteer, Well, then why would you be even ending up in Pullman at Steptoe Apartments? Because Steptoe Apartments, there's a Jack in the Box by there a couple blocks away, but really where Kohberger lived and where he would park his car, it's up on a hill, and the parking lot is damn near hidden unless you reside there. So any of those, I just never understood how that tip even, but it was a white car. It was an Elantra.
Yeah. It just makes me wonder if there was any backstory, to them. It's small communities. I know how it is where I live. Doesn't matter the town next to me. People. Was there any beef? Was there any reason that he would suspect Kohberger other than the car?
I put out a plate, I put out a video a couple days ago warning all the outsiders, you better change your plates.
Yeah. Yeah, that was a big thing, I think, because he was an outsider. I mean, it's easy to demonize someone who's not from the area, who doesn't have connections. Your family's not donating massive money, funds to the university, whatever,
Keep that university nice and shined.
Right?
Exactly.
Right.
Let's put out a book. Let's put out a book right before trial and stuff. Let's put that book out there and shine that university up.
Speaking of the book,
that was a bunch of crap too. Allowing, it's supposed to be gag orders, all this. Here he puts out a book and has a chapter on Kohberger and stuff.
Yeah.
What a bunch of crap.
I have a video that'll be dropping at 5 a.m. Central tomorrow. That is when I did my part 1 and my part 2 of CJ's Cliff Notes, a chapter 43, talking about that chapter for the book. So I put those together, and I'm dropping the video at 5 a.m. tomorrow. So you'll see that one popping out.
Did you find it? Oh, you did have a copy of the book, didn't you?
Yeah, I did my own little Cliff Notes video of it for it. I feel like you in the beginning, you hear that MPD doesn't know anything. You hear that University of Idaho is supplying MPD with information. Okay. And what I think you were on panel last time, Mr. Myers, when we were discussing this, and I said, I bet you the IT department was going into all of the emails and the apps and everything that the university owned to try and understand the truth of what took place, because they knew there was a lot of communication going on. And I think that's where MPD was getting their information from, was messages that maybe they couldn't collect or they couldn't get from interviews, because I don't think anybody was talking to him either, because nobody wanted to be the person that said something that person's coming after next.
Your theory is, and I'm not legally certain that I agree with you, but your theory is that since it's the university IT system, that they're allowed to just, eavesdrop and hack into all the students' communications. I've talked to a few people about that also I don't really agree with that. But let's, for the sake of argument, let's say you're right, and for the sake of argument, let's say that they got all the communications of all the students. What did they learn?
Some of the truth, because most of it, and I'm not saying they could do all of it. What I'm saying is even businesses can go through, if it's a company issued phone, they can go through your text messages, they can go through your call.
Business is different. Business is different from a government entity, which, it's a pseudo government entity. I know they say they're a private institution, but anyhow, my question, I don't want to argue that point. My question is, okay, what did they learn? What did they get out of all of that?
There was communication.
Well, I think they know exactly who did it. I think they know exactly who did it. I think they have all the text messages and all that stuff. That's what. So
what my question is, what is this communication? What was in the text messages? What did they learn? What's the substance of all?
Oh boy! Wow.
What is?
Well, in my opinion, it's whatever the chatter was left over, because they didn't see the Snapchat, they didn't see personal phones, they didn't see personal apps. None of that. But what I'm saying is if the university had an app to communicate, damn straight they're going through it. If they had an email, damn straight they're going through their email. They were probably digging through everything because nobody knew nothing and nobody was talking. And the only way that they could figure out what was going on was to go through them. That's why I think it took them 3 days to even have a press conference, because they were trying to figure out like what even.
Right. Well, what I'm asking you, though, is Your Honor, direct the witness to answer the question. What did they learn? Specifically, what are the facts that they were able to glean from all of these communications that you're telling me about?
That maybe they know who was standing outside the front of the property. Maybe they know based off of certain emails or with the university
that they were talking about some of the people that are actually involved.
What time people started getting there. Because you can see when the chatter, like with the Dave call, right? He woke up to a whole bunch of messages. Well, they're going to dig through those. If it's university app or email, they're going to dig through those and calculate, okay, there's a lot of chatter going on around this period of time. Let's start looking through all of the communication from here. And then they're going to look for keywords, or however they do. I don't know how to, probably keywords or something.
And so does Thompson have all of this and he's withholding? Is that why we have 11 discovery requests? I mean, I don't know. I'm asking you an honest question.
No, I think why we have 11 discovery requests.
That's a good question.
I think the reason we have 11 discovery requests is because Ann Taylor's still waiting for the video that shows BK driving where he was supposedly driving in the PCA. Yeah. And I think we still have it, not only because of the IGG, but because she wants the cell phone data. So you're telling me the DNA, which that's already questionable, no matter what information you have. What is questionable after the case? The video. And
I think there's stuff that that LE doesn't want them to know, and like text messages early in the morning at 8:30 in the morning. Who was texting who?
Brady versus Maryland. If they don't release that stuff, there's going to be a retrial. Brady versus Maryland says that they absolutely got to.
I feel like they did, and I feel like that's why, and that's part of the stuff that Ann Taylor says. This is all scattered.
Yeah, I think that's why she's asking to get it thrown out.
No, I feel like they did turn all that stuff in, text messages, communications. I feel like they turned all that in, but without timestamps, without dates, things like that make you have to like try. Oh shit! I didn't know that this text feed went with this. To create more work, and I'm saying she's waiting. The video that shows BK driving,
I don't think
they have in the PCA. Where's the video? Because I've even heard stuff like they're offering video that doesn't even have the right timestamp and is going in a different direction.
I think there's things that Bill Thompson does not want to hand over.
Well,
he's proven that. He's proven that.
But if he doesn't
have the option. That's not even.
He's not supposed to have the option. He's not. That's what's making this. That's what's making this like corrupt.
Well, I'll tell you right now. I'll tell you right now. The first trial is not going to be the last trial, and I think Attorney Logston foresaw that yesterday when he said that this case is now a maelstrom. Yep. I love that word. This case is a maelstrom, and he says that the way things are going now, these aren't his exact words, but the way things are going now, we have to get a lot of stuff here. This could be going on for 28 years. We have to make sure things are done right. And I think what he's saying is not only does somebody that is found guilty with a death penalty get an automatic appeal, I think he's talking about retrial, because if what you're saying, Tommy, is correct, that Thompson has all of this information, but he doesn't want to give it over, that's a retrial. That's an automatic retrial under Brady versus Maryland.
That's why I feel like he did turn it in, because he knows it'd get tossed if he did.
The thing is, though, let's put this into scenario. Let's put this into scenario. Let's say that they get the BK as a this tip or whatever, and they go after BK, and then later they realize they got the wrong guy.
No, I think
and they've already spent all this money. They've already spent all this money.
Kabillions.
Yeah.
That's
what I'm saying. They've been waiting for this evidence to materialize.
I want to ask Andrew this. Would they feel like they're stuck? Would they feel like they're stuck? Like if they've spent all this money, or can they drop it and go, okay, we're going to start the investigation over, which they should do.
Yes, but will they know? No, of course not.
That's what I'm asking.
Here in Massachusetts,
they're not folding when they put all their chips in.
Here in Massachusetts, we have a case that was tried 4 times. If you don't believe me, look it up. It's Commonwealth versus James Cater. The case was tried 4 times.
Wow.
And unless the state of Idaho gets its act together, that's where this case is going. I'm telling you right now, because Logston kind of foresaw it when he said this could go on for 28 years. It's not the appeal, but it's the retrial if these games continue.
And here was my prediction. Was that they were they're gonna find him guilty. And he's going to go down for this, and he'll win it in appeal, and he'll walk, and that way the old university is still shined. LEPD doesn't, the corruption doesn't go down, and Moscow comes out shining. Bill Thompson gets his win, and Brian walks free. That's my prediction.
I don't think the prosecution.
I just want to support. I don't know anything about the truth of it. Okay, obviously none of us do, but to maybe lower Tommy's blood pressure, I just want to point out the fact that we are not the only people saying misconduct.
Right.
The defense herself brought up prosecutorial misconduct.
What's that?
I think that's why we're all here.
An idea some weird in Anne's mind. She's just not sure herself if Bill is holding things back from her on purpose.
Right.
Or if it's because he doesn't have everything. But she herself has actually mentioned prosecutorial misconduct, and I think it's for this exact reason. So that she can say that if she finds out that there is evidence that he's not handing over. I don't think she knows for sure that there is.
I guess that's my other thing that's my other thing.
They're waiting. They're waiting for it to materialize, and it never did.
Yeah.
That's why she's waiting.
But I think the way she was wording things and
not holding anything
was exactly that. And I think that's one of the other points, is that she thinks that they're holding stuff back on purpose. And I think you can see that. I think you could see it in the way she was saying it. I think you could see it in her body language.
Yeah.
She knows there's corruption.
A snide little shot when she was like, and I'm not saying anything about the state. Yeah, she
I loved it. I loved it. I loved the way she was.
Oh, she went in there.
And she said it so many times, she wanted to clarify, and I don't mean this in a bad way, but she definitely did. You know what I mean? It was the most snide comment.
I don't mean to offend you, but here's an offensive comment, right? Yeah,
exactly.
One of those, but here's
blow after blow.
That's why I feel like that's why I came away from the court hearing yesterday going, that's proof to me that they jumped the gun. They expected evidence to be available. That's why Ann Taylor feels like they're keeping stuff from her, because she expects that evidence to also be available. Unfortunately, the prosecution keeps saying, we don't have anything, because they never got that evidence to materialize, to prove. When they pushed in all their chips with the PCA, they pushed in all their chips.
Yep.
That's when, okay, we're going to push them all. You don't know what cards I have. I'm waiting to see if I have a better hand than you, but really that evidence isn't going to materialize. And then when it comes time that we all have to lay our cards down, unfortunately, the bet that I placed to make you think I had something, my cards never materialized into what it was supposed to be. And I think that's why I don't see, just my opinion, I don't see Bill Thompson, because if you look at his record there, he has a pretty good record. I don't think, and this is probably going to be his last case, I don't think that he would take that chance and not turn something over and that come back to bite him in the ass. If there really was evidence to prove
what if
BK
what if LE isn't giving him the information?
That's what I've said. That's what I've said. The stuff that he's thinking that he is supposed to have or is going to materialize or supposed to materialize is documents that are redacted.
I think Bill Thompson is very
that have a header. It's a blank page with a header on it. It's a bunch of just, like I said, you're going to serve a carrot. You're not going to give them the shavings. But if you're asking for the shavings with the carrot, do you really want them? We threw them away because they're of no use. But here, I'll give you the shavings, and that's the redacted papers that he doesn't have access to, because they referred to a case a long time ago in these court hearings about another case that discussed that they couldn't get information from the FBI that had to do with DNA. They couldn't get.
And I think Ellie and Bill Thompson probably don't get along that well. do you see
I'm
it
sure
that way?
You could see him in the courtroom. He's telling Jay Logston how to do.
I don't think they're getting along too well. I'll bet you money that they went into Bill Thompson asking for like the search warrant and all that stuff, and he's
holier than thou.
He put trust in them. He put trust in them, and they came back with a turd.
Yeah, it's the I've always said it.
They came back with a turd, man.
It's the Christmas stocking with a bunch of crumpled up paper, making you think there's hot. Right? You fill it up with crumpled paper, Tommy. Don't you think there's Hot Wheels and Kit Kats in there?
You're right. I was like, Hot Wheels in there.
And then you go open it, and you're like, oh, what is this? It's like getting a present with a penny taped on a weight that's in a big box.
Right.
All right. Can I ask y'all a question? A legal question? I want to ask a legal question. So you're a judge, and regardless of what you think of him, just any judge sitting in that chair, what do you do now? The trial, the prosecutor said, we want a trial in June because of school and everything else. And Taylor comes in and says, I can't do it. It would be ineffective assistance of counsel to do it even in March of 2025, maybe next summer. What do you do? Because on the one hand, you want to get this trial going. In Idaho, apparently there's a unique constitutional provision that says you got to do it as quickly as possible and keep in mind the victims' families. So on the one hand, he wants to get it done really soon, but if he pushes too hard, now he may face an appeal based on ineffective assistance of counsel. So when is he going to schedule this trial? What does he do?
He's kind of stuck between a rock and a hard place, but I'll tell you what. I think whatever he does do is going to tell us.
Change a venue.
I was just going to say that.
If he goes real soon, that's telling me that he's opening for appeal, which I've been saying all along.
I think he's going early 2025.
Then you know he's doing the right thing.
I was just going to say that. I would say the end of 24, early 25, change of venue. Yeah.
Yeah. Yep.
Yeah, if he does the right things,
Did you all notice a kind of softy that Bill Thompson was engaged in? He said, well, and I've been practicing law for 30 years. I've tried a lot of cases. You go into a pre-trial and you say, okay, you get your book out and you say, okay, Your Honor, I'm available on this date and that. I've never once heard somebody say, well, we have to have the trial in the summer because of the schools. We have to have the trial in the summer because the high school is across the street and there's not enough lodging and the university has its, all of their events. And so then the possibility of a change of venue was mentioned. And Thompson, I think he had a brain fart because then he started arguing something totally different, which is, well, a change of venue is not going to make any sense because I have friends in Mexico or who went to Mexico.
It did make sense.
His argument made little sense. And I think it's important. Just one more sentence. I think it's important because it shows that I don't think he's all there. I'm sorry. I don't think there's malevolent intent. I don't think he's all there.
Maybe those arguments worked 40 years ago, right? But not today. Because when you first start off and you say how Boise, You first start off and say how Boise was so busy with the topic and they were talking about it and covering it like crazy. To me, that says Boise's just invested as you, mister.
Well, and that's like when the question that Andrew asked her, that goes to like, what would you do if you were Thompson and you're not getting the stuff from LE? You put your trust in LE because they begged you for, to take on this case, and then he takes on the case and they throw him a turd. Now what do you do with Bill Thompson? And that could be affecting his answers too.
You got to keep bluffing.
He's not getting the stuff from LE. LE is, I'm telling you, it's
redacted.
dirty.
It's redacted, and that's why they brought it up earlier in the court hearings, that they couldn't get evidence that had to deal with FBI or that had to deal with DNA from the FBI. They were trying to give everybody an example.
Well, I'll tell you what,
that this is what they're dealing with.
We've done it, it just shows,
because that's where they got the tip.
A lot of corruption, man.
That's where they got the tip. Now, ISP is the one who connected Daddy BK to BK. ISP was. FBI is the one that created the tip. ISP is the one that connected Daddy BK and BK. So ISP, there shouldn't be any reason why ISP isn't able to provide anything. And this is why I go all the way back to, that's why I feel like somebody that first walked in messed up, because why wouldn't LE be able to provide documents that have nothing to do with anybody else than BK and who's on the list other than BK? And that's their own people. And if you have redacted documents of your own people, well, that means your own people's in an investigation, and there is already a Brady Giglio going on, remember?
Yeah.
That's why I think, not that it's corrupt, I think there's already an investigation, because I feel one of the first people that walked in there didn't know what they're doing, and all of a sudden shit just went, oh, fuck, and that's why FBI is upset with MPD, because FBI was called in to help, and FBI's going, what the hell did you guys do?
Right.
Yep. Well, Scott Green, your friend over at the university, he in his book, I'm sure you put this in your thing tomorrow, he said right in his book, Moscow, Idaho was ill prepared for this.
Oh, big time.
And,
big time.
You might say, oh, well, it's a little town. How can I? No, this stuff happens. And even the little town where I live, I've said it before, so shut me up if you want to. The little town where I live has a protocol. And when a horrible thing happens, they put the crime tape up. They step away and call in the attorney general with the crime van. And that's what they should have done before they even walked in, booties or not.
That's why they made Brett Payne the lead investigator, because who's going to get the shit thrown at him if something isn't up to par? Brett Payne.
Yeah.
The guy that has 2 years experience.
Oh, they shouldn't have put him on there. That was stupid.
No.
That's why they did it. We're going to make you lead investigator. All right. Yeah. But really, they knew this is shoddy. This is too much, more than we can handle. If something bad happens, we're just going to blame it on Mr. Payne.
I agree 100%. I agree 100%.
He's a scapegoat.
Yep. But remember the Murdoch case, and all through the entire case, there were all kinds of questions about what did SLED do? They let people just walk over the crime site. They were just, and yet they got their convictions. So I agree with everything that's been said about, how Moscow, Idaho Police Department was not prepared, but the ill-prepared SLED in the Murdoch case got their convictions. So I don't know if it matters. I honestly don't.
The only experience they have is noise complaints and the undercover underage alcohol task force, which 2/3 of your students are already under the age of 21. So you have a humongous success rate when it comes to just.
And they have no experience in writing reports.
Right. No experience in writing reports. And then, that's why. Exactly. That's why I feel like somebody messed up, and that's why Ann Taylor feels like she's not getting the documents because really, if Ann Taylor's looking at a chain of custody for a piece of evidence, right, and she can't get it, well, that should be there. I feel like Bill Thompson's holding evidence, but the reason that she can't get it is because maybe there's some kind of redaction or whatever that's not able to be put out because, or maybe the person that was the one handling it is redacted, and that's the information that she wants.
Well, but there's a way to deal with there's a way to deal with that. I mean, I get redacted documents all the time, and I swear a blue streak. But then what you do is you ask for an in-camera review, and the judge decides.
That's what they did.
I didn't know that.
Yeah, they did. They asked for an in-camera review
of the documents that you say are redacted.
Exculpatory evidence? Well, not specifically.
Well, that's what I was asking you about. When I get documents that are redacted, they took the Sharpie pen and marked them all up. You ask for in-camera review, and you go into the judge, and they can't bring in redacted documents. That's sanctionable. So there's something wrong. There's something wrong here.
Why wouldn't she be able to get the chain of custody?
Well, if they don't have the chain of custody, it's inadmissible at trial.
Why would it be inadmissible? It's important
if you don't have a chain of custody on evidence, it's inadmissible. They bring in a drug test. I'm trying a drug case, and they didn't have the chain of custody.
No. Oh, so even if they don't have the chain of custody for the sheath, for the sheath,
they've got to have it.
When the IGG, like the chain of custody for the IGG,
there can be no break in the chain of custody for anything at all. Rather, it's the DNA sample that came off the sheath or the sheath itself.
Absolutely.
You have to have literally with name of the officer, like the date, the time
transported
stamp. You have to have all of that. And it has to be able to go chronologically minute for minute. And there cannot be any time space where there's not like an officer who can be
that's why she wants
for holding.
That's why she wants the records, and that's why she wanted to know the records of the people that handled the DNA. She wanted to know their background. She wanted to know their work history. She wanted to know what they got reprimanded for. And that's what she's talking about is the IGG, the chain of custody. She wants to know, did this person that handled this DNA ever get in trouble for mishandling DNA before?
Anything else at all?
Mm-hmm. Well, that doesn't go to admissibility. That goes to credibility. You've got to have the chain of custody that forensic was just talking about to get it admitted into evidence. Now, when you're talking about the experience and record of the people that handled it, once it's in evidence, now that's credibility. So if there's a chain of custody, it goes in. But if she can't get the backgrounds of the people that handled it, that goes to the credibility of it, and it can get knocked out.
But even the chain of custody itself is. Go ahead. Sorry.
Oh, I'm sorry, honey. And then to tie those two things together, she is searching for a credibility issue so that she can look for a hopeful admissibility issue. Yes, I do agree with that. Yes.
Yeah, and that's what I'm saying. When it comes to the chain of custody of the IGG, where the sheath, where you got the DNA from, where the DNA went from here, from ISP to Orthram, then to FBI, that right there, you should already have a chain of custody as page one. Page one. So if you can't get that,
if you recall,
they're not trying to get that up.
Why can't you?
Because they haven't phoned it up yet. Someone who took evidence and had it in her trunk for days. Okay, that can't be the case with the knife sheath. But the sheath was found on the 13th and not tested until the 20th, and she puts that in her order for. I think it was her stipulation for a protective order. She put that the sheath DNA was not processed and found until the 20th, along with the glove. So the two most important pieces of DNA in the crime were not processed until a week later, and I don't think she knows why. Right. Just so you know that, now, I don't think she knows why, and I think that she's wondering if that's another situation.
That's a problem. That should be a huge,
and I think she's wondering if there is a chain of custody issue straight out the gate with that knife sheath from when it was collected on the 13th, but then not processed until the 20th, because for those 7 days, there would have been no reason to not be on the sheath and processing it.
Exactly.
You should have known that there was, you should have known about the unknown male on the glove and the sheath way before the 20th.
Right.
Yeah, and just how.
And you look at the DNA
And
dirty glove
simply-
video that I showed you guys, and you're going to tell me that wasn't contaminated before they even walked in? Just saying.
Right.
And to
Yeah.
simply swab the knife sheath, swab the glove, whatever it was that they were doing, and actually run the process to figure out just if it's a male or a female, and then if they're in CODIS, that shouldn't take more than like
and
72
just-
hours. Not in a case that's like
the
this
crime
big.
scene, just the crime scene alone, man. You know, like how long did it take Fry and Payne and everybody to get there? So you got all these cops walking around that aren't even supposed to be touching it, but how much you want to bet they were in there looking around and
messing
then
stuff up.
It's a contaminated crime scene. Period.
Too big for my britches. I know what the hell I'm doing. I'm too damn cocky. I know what I'm doing. And then really you don't know because DNA dirty gloves. The chick didn't know that when you drop a glove on the ground and your partner steps on it multiple times and does a twist and shout,
right?
And then you pick it up and you still use those same gloves to then get clean gloves to put in your pocket to go into a crime scene?
What? Exactly. Yeah. It makes no sense. And I think that's where it's going to come down to in court when they try this case. You know, the fact, really asking the hard questions of Orthram. You know, how long? What is your, how good are you at this? How many cases have you done? You know, things like this. And then you get into the dirty gloves. And I think it's going to be a real problem if it comes to trial. I mean, and I don't
a huge problem.
I like what you said there. I just want to piggyback off that. So that is a part of what she has actually talked about. Her third motion to compel covered corrective action and whether or not they had any like quality assurance issues within the 6 months before testing the sample and then within the 6 months after testing the sample. So if they did it in like December-ish, she wants to know all the way back to June of 2022 and then all the way forth to about May of 2023 if they had any actual like lab errors, any systematic errors, any human errors that went wrong, anything that was done intentionally or otherwise that resulted in unexpected or inaccurate results. So she's 100% looking for what you were just talking about.
As well she should.
Exactly. Yeah. And when you and think about it, when you're talking about that DNA, you're already at Q-tip level before it even gets to Orthram. Orthram, I'm sure, was excited to take it on because really what Orthram does is they're looking for even just a Q-tip of something. But they were stopped in the middle of their own investigation, and then it went, to the higher agency, and then whatever took place there. But when it comes to this DNA, we've heard all of these experts, the ladies that are like the leading people of the practice, C.C. Moore and Vargas, and I can't remember the last lady we just watched on Surviving the Survivors podcast. She did a great job too. It's not a science because it's not 100, it's an art. And so to rely on this kind of DNA, that this is what you're going off of, and then all of the possibilities that that contamination can take place, like with what you all are discussing.
Yeah, C.C. Moore actually said it. It's on one of my videos. I found. She actually said that it should never be used in the court of law.
No. It's used to exonerate, not convict. It's used to exonerate because they're manipulating DNA. It's not a complete profile. It's like I compare it to a tire that has a bunch of holes and you're just squirting Fix-A-Flat all over it.
Yeah, I got that video on one of my shows. She comes right out and she says it should never be used in the court of law.
Yeah, I think she was on the Presumption podcast when she said
I cited
that's what it was. Yep, Presumption. Yep.
And I cited 2 Connecticut cases that go into touch DNA. One of them was a serious assault case where a conviction was overturned because it was based in part, it was just one of the things, but it was based in part on touch DNA being used in the court. Actually, in the decision that I cited, went into detail as to why touch DNA should not be used to convict and why they reversed the conviction, at least in part, on the touch DNA. And the two different Connecticut decisions go into pretty good detail on that subject.
Yeah, I even covered one. Mark Carver. If anybody wants, it's an old video I have. Mark Carver case. He was fishing with his cousin a few hundred yards away from where a lady was unalived in a vehicle, and they went up to interview him. He shook the officer's hand, and the officer walked up to the crime scene and opened up the back door of the victim's car. And next thing you know, this man is convicted of unaliving this woman based off of touch DNA.
Touch DNA.
Yeah. It's dangerous. It's dangerous. And when you see people outside, because Johnny Cochran said this in the O.J. Simpson case, if you can question the contamination before the crime scene, you can question the contamination inside.
Sure.
It's when you see the dirty gloves and you see them walk in and you see what they're doing, who's to say that lady wasn't at the Jack in the Box in Pullman, got skin cells on the bottom of her boot? She's the one that stepped on the glove. The other lady picked up the glove, and then they went in there and they picked up the sheath after they were taking photos, because they were taking photos of everything.
Well, plus, CJ, you know a lot more about what happened in, right the first couple of days. I'm following the legal end of it and going forward. Didn't they say that the Moscow Police Department has something like 34 officers, and at one time all 34 were involved in that initial investigation? How many of them tromped through that crime scene?
Exactly.
Right. Especially the first few. And when you're going off of Brett Payne, the lead investigator, normally when you're getting a probable cause affidavit, number one, the coroner's already there too. If not there, shows up shortly after. The coroner doesn't have to wait for the MPD to get done doing whatever they're doing for her to show up.
Here's another thing I don't think people realize is how important this case is, not just to Idaho, but to the whole United States, because everybody's watching this. And if they can get by with this IgG stuff, and they can get by with all of this, that's very
they did
effing scary.
Mark Carver. Mark Carver.
Very, very effing scary. This is a huge case for this country.
Yeah, in the bad and the good, but I'm saying Mark Carver was already convicted that way, Tommy. Mark Carver was convicted from touch transfer DNA, and it was just a few years before BK.
But this one's going to lock it down. This one's I think is going to lock it down. And that's why.
It's all the social media, and that's my point. Because if social media and YouTube was where it's at in the true crime community for Mark Carver would have been today's BK.
Right.
It's the social media in the day that.
Well, I think it's really important to this country
with the DNA technology. It's like OJ's case. That's why we're doing the members only. OJ's case was a new DNA technology. It was all about DNA. Barry Sharp. I'm sure you might be a fan, Mr. Myers. Barry Sharp was.
From Connecticut.
I mean, on point with that DNA, and it was a brand new. He had to be the one to introduce the jury and help them understand all the complexities with the new technologies. And that's with this case, that's what they're going to be doing with this case, because it's going to be the same thing, where now we also have to have a jury be educated and help understand this new technology that we have when it comes to the touch.
This new technology should not be used the way it's being used in this case, and that's what makes it scary.
No, and that's why
it makes this really, really scary.
That's why I think the experts are going to do I think the experts are going to do a really good job combating the effectiveness of the DNA when it comes to trial. What do you think, Mr. Myers? Do you think? I think the video and the cell phone cast data is going to be more detrimental in this case than the DNA, because the DNA, when you get an expert from the defense up there, they're going to tear that to shreds.
Well, Ann Taylor said yesterday that she already has several, I think you said several experts, and gosh knows how many other experts she's going to have. We were speculating on my podcast the other day, how many experts are there going to be in this case? How many were there? Were at least the number was in the teens, the number of experts there were in the Murdoch case. So I'm guessing there's going to be at least that many experts in this case. So the point of an expert is not to have somebody that's really up there and they can describe how to get to Mars from here. The point of an expert is somebody that knows his stuff, but also can communicate in a fairly simple way to the jury. And that's how Barry Scheck was way back in the 90s. You and I are both old enough to remember that. But you need an expert that's able to simplify it. And there's two kinds of intellects. One that's like up there and can't even talk to you. But there's another type of intellect that knows that in order to impart his wisdom on you, he or she can communicate in simple terms, and it's not that hard. So
especially with this, because we saw Vargas up there in one of the court hearings, and Vargas, totally, just in the 20-30 minutes that Vargas was up there.
Remind me who Vargas is.
Elizabeth Vargas. I don't.
The one that the FBI.
Okay.
The one the FBI. Yep, exactly. Yeah. When she revealed
the tattoo girl with the blue hair.
When she revealed what Ellie could do to get around all these laws, right? Yeah. Oh, you got to watch it, Mr. Myers. I'll send you the link here after the show. Because after what she said and what she said about the shadiness, and she even knows and firsthand.
And then the FBI gave her a visit after that.
Bill Thompson. Yep. Bill Thompson
all
says,
of a sudden, the prosecution sent the FBI to talk to her. Yep.
Yeah, because Bill Thompson's like, I don't know how to.
Yeah, I remember this now. The more you guys talk, the more I remember this. Yeah.
Now, isn't that like tampering with a witness?
No, it's the federal government.
When Bill Thompson sends over the FBI.
At first, she made it seem like she felt that way, but then apparently, when they started to question why they even spoke to her, then she didn't have a problem with
what she said didn't match up to what she had already told them, and basically she probably didn't tell them the corruption that could take place because they probably didn't even ask her about it. And Ann Taylor, being Ann Taylor, it was like, hey, and Vargas had to be honest, and she was, and she even knew before she said it, because you can look at it. She paused and she goes,
she
man,
paused.
She's like, oh man, I'm gonna be uncomfortable saying this.
I think once the IRS called her, that's when she kind of backed off and said, oh well, never mind, because the IRS I shouldn't even be talking like this because they'll be knocking on my door tomorrow. But don't even begin to pretend to tell me that they don't do political stuff.
Oh yeah. So no, and that's why I feel like the experts are not going to have a hard time disputing.
My phone's ringing.
It's all good. They're not going to have a hard time disputing the validity when it comes to the guilt, because there's so many questions. You could have. Hell, we watch these programs. They're good enough for us, and we don't know nothing about DNA. We can see that there's shoddy stuff about it when it comes to this type. Yep. So you get Vargas, you get CeCe Moore up there, you get some experts. I bet you she'd make the prosecution look like a fool when they're asking her questions when it comes to, the type of DNA. That's why I'm saying I feel like it's the cell phone data and the video that is going to be really key, and I don't think she has any the stuff that they claim in the PCA where he's going from here to here. I'm sorry, even the A&W doesn't have a good camera that's going to capture the car. A&W is only capturing from half the window and up. That's it, because of bushes and then the roof that's on the gas pumps. It's not going to give you a good view. So there's a lot of these views that's going to be ring cameras and things like that. When I drove the route, there's not much, unless you're talking street view, which you could have really good clear pictures. We've shown the pictures of the Moscow City cameras in Pullman, and you could maybe not get a plate, but you can see how many people are in a car. You can see the model and all that other stuff. It's pretty clear. And I don't even think they have that.
Well,
Which
there's a
they
wild
should.
card. There's a
Which they
wild
should.
card. What about good old Bethany Funk? What is she gonna say?
Well,
And-
you saw the shade on the
She's got
window
something.
that was stuck open even after everybody was outside of the house. You see the pictures from
But
right
what is she
after the
gonna
crime took place. And
say? But what is she going to say, and why is she so reluctant to cooperate with either side? She just, and moreover, I have mixed. Exactly, but what is she going to say? What are the words that she's going to use?
It was a girl. That was a girl. It was a girl.
And moreover, I have mixed feelings about this new TV setup that the state of Idaho set up for Judge's YouTube channel. But
why?
They're probably gonna turn it off when she comes in, because that's one of the things the judge said, that protection of the witnesses was one of the things they were concerned about. So are we normal, peons gonna hear what she had to say?
Will we get a tweet? I don't think we're gonna hear it because he's pretty strict already. I don't think we're going to hear it.
But they're trying to hide. What are they trying to hide?
Are we going to hear it? Are we going to see a tweet about it?
I don't get it. They supposedly got their man. Then what are they trying to hide?
They're trying to hide their cards.
If they're so confident that they got their man,
they're hiding their cards. They're hiding their cards. Because they bluff. They've been bluffing the whole poker match. They've been bluffing.
Yeah, they've been bluffing.
Since the crime took place.
Shouldn't be allowed. That shouldn't be allowed.
No, it's a bluff. It's a bluff. But B, I hate to say this.
Yeah, say it.
I'm gonna get comments, but it's kind of the Idaho and the Idaho and the Moscow police handling this is like the local little league team going up to New York and playing the Yankees. Yep. It's just it's two different leagues.
It's been a joke. It's been a joke.
It's just, I know I'm going to get horrible. Oh, there's somebody that gives me these horrible comments and tells me, you're a lawyer. Don't you know that you have a duty? Yeah, I know I have a duty, but I have the First Amendment right.
Who that is too.
Yeah, you got a brain too,
Well, I don't know. I wish I knew. And I told them, I said, geez, if you want to identify yourself and not be, anonymous, you can come on my podcast and we'll talk. But you're not going to shut me up. I'm not going to be intimidated. No. I'm sorry.
No.
Why? Who you think you know who it is?
Oh yeah.
Who is it? Tell me.
I don't.
No.
Oh, come on now.
Say it in the private. Say it in the private chat.
Bad politics. Bad politics.
I'm just a little guy. I mean, my podcast is little. I'm tiny. So why would they bother with me?
Oh, Andrew, they bother everybody. Trust us.
Anybody. I'll send you. Give me your email, and I'll send you an email.
All right.
Anybody that talks about this case, the bull crap, especially if it has anything to do with questioning the case.
Pebbles.
I'm sure all of us up here get some kind of,
Yeah, my girls are all they know who I'm talking about.
But it's all good. It's all good. So, so I don't know. When I came away from that court hearing, to me it felt like Ann Taylor. At first, I liked what Jay had to say because he made a lot of valid points, and a lot better than the last court hearing. And when I heard Ann Taylor say that she didn't have any issue or response or didn't care to go on, when it was discussing the IGG and stuff like that, that's when I really felt like she just started swinging, when she was like letting everybody, we've been asking for this, we still don't have this, because the judge kind of opened himself up to it. He said, well, what could we possibly do to get this to be sped up to 2024? And she's like, well, Judge, we need time to do this and we don't have this. And she just started letting everybody know a lot of the stuff that they're missing. Yeah. I thought yesterday's court hearing was fire. I thought it was the best one to date out of all of them
Yep.
that we've
Same
had, and
here.
I thought it was the most telling too. Like we learned a lot, even though we weren't told a lot. We learned a lot. I feel like too, just from
You can
even
tell
if
the
something
way
wasn't
by the way things are worded, body language. It's just good to see. Good to see the lie. Good to
Well,
see.
this is the first time we really got to hear them talk about this fact that there have been 11 discovery requests. Ann Taylor kind of talked about what she's looking for, why she's looking for it, what her frustrations are. I mean, you were talking about that film that's coming through in pieces before, and that's just one of the things.
Right.
So yeah, it was very enlightening. And you know that this is just the tip of the iceberg. You know that she's maintaining a fight on a lot of other issues, the experts, whatever else. So it was real. It was a good hearing. We all got a little glimpse after a year of just being shut out.
Mm-hmm. Yeah. Also, what do you think when it comes to do you think they're going to get the IGG? Because ever since last October, November, I've just said they're going to wait until it's going to be February or March. They're still not going to have it, and the court's just going to move on. They're going to have to. What do you think? Do you think that would be a possibility because we are getting close to February, there's still nothing. She proved it yesterday in the court hearing. They're still waiting on the same thing they've been asking for the IGG, the stuff they were supposed to have handed over December 1st.
A portion.
Yeah, a portion. Do you think that because they were supposed to hand over everything, right? December 1st, handed over everything. Do you think that they're going to get to a point here in the next month and a half where do you see them moving past if they don't get it? Because they're being held up on all this discovery because Ann Taylor can't even give them a date.
I think that Ann may have said that or maybe she didn't say she got it. Maybe it was just that the prosecution responded to one of her discovery requests and stated that they actually had the tree. What they don't have is like the notes that go along with the tree. And she does need that because she is building her own tree, not just for the purposes of what she said yesterday. Okay. Not just for the ABA, but because she also needs to build her own tree to compare theirs to know if theirs is correct, to find out if they got it incorrect. So my personal opinion is take the tree, even if you don't have the notes, because the notes will only tell you why they put someone in that place in the tree, but whether or not they belong there, you can still figure out. You don't need their notes to be able to determine if that tree is correct.
Right. Not for the tree. You need the IGG that you still need showing that there's a connection of how you got to put BK's name.
Yeah, I think she wants the IGG for a different reason. I think it's not how did you put his name on the tree. I think she's actually trying to figure out if there was even enough sample for them to have built this STR profile and then built this this SNP profile. And I think that all of that plays a part in getting all of the IGG discovery in general. But I think that she's actually literally just looking for a protocol issue within the family tree. Yeah. I don't think she's looking for cousins to try to blame this on her. I mean, I do think there are some that she could, but I don't think she's looking for cousins to try to blame this on or anything. I think she's literally, and then that says something to me as well. So whatever case it is that the prosecution feels like they have built, your best bet as my defense attorney, and I'm not looking at this from Brian's standpoint, I'm putting myself in his shoes. Your best bet as my defense attorney is to pray to God for a Hail Mary that someone did something wrong. That's the circumstance we're in right now. Is that why we're talking about and not just mentioning because it's part of my job to get a mitigation specialist, but rather you're talking about it in depth as well, publicly now in this courtroom. And it just, I don't know, all of it together just makes me feel a little uncomfortable about what she may think of her client. That's, I don't know.
Interesting. That's interesting.
Yeah, that's interesting. That is interesting.
That is interesting.
Here's
and
what
I
has to
totally
happen.
agree with the IGG. Yeah, what's up?
Here's what has to happen. The judge has to say, okay, I've heard this. I've been on this case for a year and a couple of months, and I heard that these competing pressures that, we have to remember that this is the 4 young people that were murdered. And I say the word anyhow. And that pressure against getting it right, as Logston said, and as Ann Taylor said, the judge needs to step in and say, okay, enough. We're going to have deadlines. And this is what happens in my cases. And I've been involved in multi-party civil cases that go on for years and years and years and years and years. And the judges finally say, listen, get in here. I'm giving you deadlines. Discovery is going to be done by such and such a date. Prosecution, your experts are going to be done by such and such a date, June 1st. The defense, you'll have another 90 days, July, August, September, to get your experts in, and then we're going to have a trial next March. That's the way it's going to be. And if there are still these fights, oh, I don't have this, I don't have this, we can't get this from the other agency, start sanctioning attorneys. It happens in my jurisdictions when attorneys are given deadlines that are reasonable deadlines, and they do not comply with those deadlines, they are sanctioned. What do the sanctions mean? They can be fined, their firms can be fined, and they can be prevented from arguing that particular case. And I think it's time that the judge step in and set some guidelines, set some deadlines, and yes, set a trial date. If you're not ready,
it's hard,
you're sanctioned.
It's got to be hard, though.
I agree.
It is hard, but that's why the judges are there. And I think I watched Judge yesterday in those 4 little boxes, and he was taking notes, and you could tell he was very thoughtfully approaching this thing. He was, when they said alibi, he wrote down alibi. He was taking notes, and I give him a lot of credit, and I think that he might do the right thing. I think he might do the right thing and start setting some guidelines, because this business of looking backwards, what happened, who was there, what were they, the DNA, the car. It's BS.
But he already gave him a date. He gave him December 1st to hand over.
Well,
everything.
Well, no, that was just one little thing. That was just IGG. No, I'm talking about deadlines for everything. I'm sorry. I'm talking about deadlines. Yep. Here's your discovery
I'm just
deadline.
Saying, but I'm bringing up the latest deadline, which is the IGG. I didn't finish. And
I'm sorry.
When you're bringing that up and you're saying, here's the deadline, and they still need the IGG, well, then you didn't follow the deadline. So
sanctions.
Yeah. I mean,
you didn't provide.
I don't know.
How do you sanction? What do you mean by sanctions?
Well, if the attorney in the courts where I practice, at least in Massachusetts, I've been involved in multi-party litigation that goes on forever and ever and ever and ever and ever. The judges say, all right, here's your deadline for everything. IGG, forget it. The car, forget it. Yeah. Everything. Your discovery deadline is X. And if you don't get it out by then, after many, 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 many months, this is.
Well, when would he reach that point, though?
Can you get fined?
This is ridiculous.
Now,
when would he reach? Like, so do you think, because he said he still has to decide?
That's right.
Right?
That's right.
Do you think he's going to come out and come up with a date, like you need to hand everything over by the spring of 2024 then, or something? Or
I think that's what needs to be done. That's my opinion. It's only my opinion, not my entertainment. It's my opinion. I think that they need to start setting, because this is going back and forth and 11 discovery requests. Yeah. No. Tell me what you need, Ann Taylor. Prosecution, you get it to them. If not, you're sanctioned. And what that means, Tommy, is that if you get a sanction, you can be fined. Your firm can be fined. The attorneys can be precluded from arguing the case. Or, for example, if you don't come up with the evidence in one area, that evidence can be precluded from trial. In other words, if they don't come up with all of the IGG that he's ordered, you can't get any IGG in. That's what a sanction is. And why not? It's time.
They need to do that. Yeah, there's no doubt about it.
This case is going on long enough.
Yeah, it is. And they should have had they should have had all the stuff in the first place. Even the stuff that they're saying they don't have that.
Oh, I agree.
Is in the PCA, because if you already had it for the PCA, you should have been able to hand it over in February when they first asked you for the
absolutely.
discovery.
Yeah, I agree.
You know?
Yeah. I agree.
So yeah, I don't. How can they, if they're, I don't know. It's so what happens if they, so say they get to, say the judge sets a date for spring of 2024 for everything to be handed over.
That may be too soon.
What? But say he does. Say he
Yep.
does. Say he sets the date spring of 2024. All right. And then what happens if the prosecution, because like I feel like they're still waiting for evidence to materialize. So what happens if evidence materializes after the date that they were supposed to have everything turned in? It doesn't matter. They shouldn't even be working on it anymore, because once they got that date, nothing else is going to be, anything else that materialized isn't going to be.
They would have to make an argument that they couldn't have, through due diligence, have produced that up to the deadline. They would have to produce evidence that, Your Honor, we tried, but through due diligence, we couldn't get it until now. And then the judge makes them squirm for a little while. I may preclude that evidence. You didn't bring it up, I may preclude it. I mean, in civil litigation, this happens all the time. In civil litigation, if you're given a deadline to produce something and you don't produce it, it can be excluded as evidence at trial. It's as simple as that. Now,
yes. That's what he needs. That's what he needs to do.
That's what I'm thinking.
It's true. It's true that if you can't get something through due diligence, I mean, I think I find a credibility problem that, there's 3 agencies and they can't, get it. No, I don't buy that. No, this is a big case. These are big boys and girls. And so my feeling is that in a case like this, they can have a conference. They don't have to get on an airplane and fly. No, they can get on the Zoom and say, listen, the judge is telling us we got to hurry up and get off our butts. Yeah. And that's what they need to do. That's what I mean. Otherwise, Ann Taylor, God bless her, she's got a horrible job, and I think she's experienced, and I think she's good, and I think she's doing the best she can. But if we give her until, and she says, if we give her until June of 2025, and she says she's nervous about that, she's going to come back in June of 2025 and say, I need until June of 2026. At some point, some kind of deadlines need to be imposed on everyone, on all the parties.
Right, because he's already been sitting in jail for
and because he's going to sit there even longer. Yeah,
right.
Yeah,
that's
you
insane.
extend it even more. I mean, yeah. It's the guy. What if he isn't guilty?
If he isn't, if he is in fact somehow innocent, then why would we do this? And why?
That's a tough one.
She do that? Why would he agree to it? It's just, I don't know. It's just, all of it just seems like eventually he may have an issue with his attorney.
Mm-hmm.
Well,
eventually he may no longer like her, and feel like she's doing, I think she's doing the best job that she possibly can for him right now. But eventually he may change his mind about that. If he would agree with that now, eventually he may change his mind.
Well, defendants have been known to do that. I mean, it's very common. As I said earlier, the appellate issue of ineffective assistance of counsel is very common. It happens all the time. And she kind of alluded to that. Look, if I don't get this stuff, and if I'm forced to try the case this summer, I can't be effective. So, defendants have been known to turn on their counsel on a dime.
Yeah. I mean, I don't know. I could see him thinking that. I mean, because really, I don't know. I feel like she's doing a great job.
I have a feeling there's going to be another lawyer coming onto the case very soon.
What do you mean?
Oh, yeah.
That's all I'm going to say.
Oh, you mean another lawyer? Did you say another lawyer or another lawyer?
Another lawyer.
Oh, okay. Which to replace Ann Taylor?
You think one's getting put off?
I don't know about replace. That I don't know yet, but
an addition.
There might be an addition coming, and it'll be up to Brian if he wants to. I can see it. To go that way or to have them as a team.
But the state's paying for that though, right?
Yes.
Unless you have someone that goes pro bono. Unless
That
you
would
have
have to
someone
be in
really
your budget.
famous that goes pro bono.
Yeah. I mean,
Well, a young
I'm sure
sharp
they
attorney
wouldn't.
would hone his chops on this case and make a
Yeah, I'm
name for
sure they
himself.
wouldn't turn it down. Yeah.
Yeah.
Plus, you could the book deals you would get
Yeah.
after the trial, right?
But if you're Brian
Um,
Koberger, you want somebody with experience in a capital murder case. You want somebody that's done this before. You don't want some, first year law students. Some of them are great. Some of them need time to learn. So you don't want somebody that's learning. Not on this case.
Right.
No, not in this case. It would have to be somebody that's like been a partner for 14 years and things
You
like
want
that.
someone
That's famous. That's what's needed in this case.
and
especially
someone
this.
with enough sense to not come into it overconfident and rather come into it and say things like, I'm nervous going into this
Yeah.
thinking that summer 2025 is, she's got
Right.
her head on straight. She's really prepared to actually try and defend him.
I got a sense
think
that
she's
Ann
doing great.
I got a sense that Ann Taylor was very sincere when she was giving the cautionary warnings that she did about, not having the evidence and not having the time. And she also
Yeah.
alluded to the fact that she doesn't have resources to go through these 13,000 file drawers herself.
Mm-hmm. Yeah, you could hear it in her voice because, like, when she's saying, like, we really are, this is our life. We really are working this hard, and you could hear it in her voice. In that court hearing, I mean, I thought she did a great job. I would just because things are dragging out, I don't see him thinking that. I could see him thinking, yo, she's really got my back because she could easily just be like, okay, let's go to the next. I don't need this. Let's just go. Judge, let's go for 2024 spring. I got a question, another one for you guys. What did you guys think when she, in the last documents before the court hearing, where she said that they wanted the motion to unseal, where they agreed based off of communication with the prosecution, they agreed to seal some things, and now they were wanting to unseal those things. What did you take away from that? Did you, and he denied it, obviously, because we all knew he probably would.
I have an opinion on that. So I think
Yeah.
that Anne agreed initially, thinking that when she presented the issue at the hearing, that it would not be denied. I think that wanting it now unsealed is like a slight at the judge and the prosecution to get the information that she feels like is important out there for us. I feel like had they just, if it hadn't gotten denied, then obviously there would be nowhere for her to go with this.
They need to open
it
it up.
Her, then she wouldn't be snapping back. I think that's just her biting back right now.
Yeah, like because he denied it, that's why she's like, well, she took her opportunity. You're going to ask me, Judge. I'm going to open it up.
And I do want to point out that is the only thing. The stipulation for the motion for the dismissal for the grand jury that she's requesting is the only thing that she is asking to be unsealed. She has not asked for anything else to be unsealed at all. So I think there are some people that are misconstruing the whole precipice of the idea and thinking that she was requesting for everything to be unsealed and pushed out there.
No.
But that's not what she's asking.
No.
She's only asked for the information pertaining to the grand jury. And I believe it's specifically the argument pertaining to like the probable cause beyond a reasonable doubt thing. I don't even think she's referring to the prosecutorial misconduct and stuff like that she was actually arguing in the private portion of the hearing.
Right. I think I was really shocked when they started arguing that in this hearing, and the only thing they talked about was the standard. I mean, there were other issues, as you pointed out, the prosecutorial misconduct. The other issues included whether there was a quorum. The other issue was whether exculpatory evidence had been presented, which it must be under the Idaho court rule. So I was surprised that they only argued that one issue because it's so clearly wrong. It's just so clearly wrong. I mean, criminal procedure 101 in law school teaches you that at a probable cause at the indictment level, probable cause is it's black letter law. It's really not an argument. And I went into the being licensed only in Mass and New Hampshire, I went into the Idaho rules, and they're very clear. The Idaho rules and the case law are very clear that at an indictment, the standard is probable cause. So I don't understand why they're sticking her with just that one issue, because it's not even an issue.
And the entirety of Jay Logsdon, like, he literally came into this situation to argue specifically that, and he boils my blood. I know that I heard some people earlier saying, like, I think he's awesome. I'm not debating whether or not
he fumbled that.
I am literally just saying that I do not understand how he can stand there and even in that. Oh my God, it just drove me nuts.
Tell us.
No, it's true. No, go ahead. It's true, because we probably feel the same.
It's just the idea that, like, you came into this specifically to argue having the indictment overturned. And for whatever reason that it is, what you came to present to us is, and I don't know if maybe like he's helping Anne present the other half of the issue that's private, and maybe that's what she needs him for. But the part that we are seeing him actually enact is the most ridiculous part of this entire case.
Oh, I agree. Absolutely.
It's the one document. Like, there are so many documents on iCourt. That is the one thing that I cannot make myself read it. I refuse. Myself refuses every time that I look at that document. I cannot read it. I can't.
Forensic, how do you really feel?
And when he stands up to argue that,
I think you better lower your blood pressure.
That's the one that gets me, Timmy. I promise.
He got you back.
I don't care about anything else that they argue. Yeah. I swear.
Gotta lower that blood pressure.
There are even conspiracies out there that literally bother me less than Jay Logsdon arguing the beyond a reasonable doubt thing.
That's ridiculous.
Because I've never heard of that before. I can't imagine why he would want to take that just to the Supreme Court and argue that in front of this. It's so insulting to yourself, and it makes me feel secondhand embarrassment for him, because he thinks as an attorney that he can take that to the Supreme Court and change their mind, and then thought that it was literally exponential enough to change the last 40 years of history. That to me is like, that's so insane. He's just got, he's got some gonads. That man,
the reason that they were going through the Rule 12 interlocutory appeal route was because, the first step is you try to get your own court's permission to go up. They didn't get that. To get the Supreme Court to allow you, sua sponte, to take the appeal, it's not going to happen, because you got to go through a bunch of different steps, including a writ of mandamus, which is ordering the district court to change its mind. And you have to convince the Supreme Court that this is a major matter of not only public policy, but also something of which reasonable people can disagree. Well, there's no disagreement. The Idaho Supreme Court, I don't know who's on it. I can't name a single judge. They're going to laugh at him.
The Supreme Court would have to turn back to Judge John Judge and literally tell him, you made the wrong decision, and therefore it had to come to me. And now I'm so upset with that you need to change that before I have to change that. I'm giving you the final opportunity to do it before I have to do it, because if I have to do it, I'm going to be pissed.
Ain't happening. I don't know a single Supreme Court judge in Idaho. I can't name a single one, but I know that they'll just laugh that writ of mandamus out of the court. They won't even look at it. It's not going to happen.
That's why I feel like the 6 jurors that wanted more information at the secret grand jury hearing, I felt like they just wanted a photo with a car. And the easiest argument for the prosecution to make was, look, we only needed this piece of paper that didn't have the photo with a car to do what we needed to do, and neither do you.
Interesting.
So that's what I think. It was the photo with a car. I think that's the easiest to explain. That's the one thing that's missing out of the PCA. It's the easiest to explain and understand, a photo with a vehicle. If you have all this footage, it'd be hard to explain it. The DNA, the cast data, a lot of those things, you're going to have to bring in experts maybe to help them understand. But a photo with a car, that's 10 seconds. of them looking at it. Oh, okay.
I really respected the judge when he said that even if this appeal goes up to the Supreme Court, even if they allow it, okay, fine, the indictment gets knocked out. They'll just either indict him again or do a preliminary hearing. So it's just going to be another delay of probably a year, because the appellate courts, God bless them, they don't work fast.
I don't think they care.
No.
I don't think the prosecution really cares. They just wanted somebody to get arrested before the new semester to stop the avalanche that was about to happen, that they couldn't recover from, and that's all they needed. When I look at one of these other cases where Ann Taylor was involved and she got an acquittal of somebody that was being charged for unalive, and when she got the acquittal for her client, the prosecution team in Kootenai County was saying, we're sorry that the jury didn't see it our way, but because we felt that this person was so involved in the crime and they did what they did, we don't have any interest in exploring any other tips or leads. They didn't care. They don't care. They just wanted somebody arrested. If they lose it, it is what it is.
Yeah. I mean, that's the kind of thing that makes me look at Delphi and say there's a lot of parallels here, because I feel the exact same way. There comes a point where there's too much political crap going on, and you've got the university, you've got LE that are not trained, okay, for this kind of crime. They're just not. And then if you have a scapegoat, whether BK is guilty or innocent, it's really irrelevant, because they can say, hey, if he gets, if he walks, then they can say, hey, we got your guy. And I'm sorry the court didn't see it that way, but we're not looking for anybody else. And that's this exact same thing that's happening in Delphi with a lot more BS. And so, I mean, it's a win-win for, it doesn't matter.
It's the same thing that they've been telling the families. This is why it's so hard. People want to talk about how hard it is got to be for Christy because it's another drag. Well, you know what? Maybe if the LE there wouldn't have bullshitted them so much about how much evidence they got, then they wouldn't be sitting there, because when you know how she is, and how she's really focused on BK and it's him, and no ifs, ands, or buts. She's totally Steve G. He's like, yo, things don't make sense, but with her, she's so gung-ho on it, and with I can imagine what she felt like yesterday after the court hearing was then, because she's waiting for that trial date. She's wanting to get to these next phases, and that's the biggest injustice of them all also, is bullshitting these victims' families thinking, we got all this evidence. You hear them say multiple times, they got so much evidence, they're just trusting them. And that's the worst part of it, is they have to go through this because there's not the evidence that they claim to the families that they have. And it'd be hard. And, it's like they claim to care so much about the families. The Gonsalves family don't even have an inventory list of the items, whether they have them or not, or if something's in custody or not, or if it was thrown away or not. They don't know. They don't know.
I can understand these families, just wanting to believe that BK is it, that the police are on it, and they've got the right guy.
They have to.
Look, yeah, it's part of their grieving process, because they're looking for some kind of closure. It's never going to make their life is never going to be the same. It's never going to be okay, but it's part of that process that they have to go to. And so if you are saying, that, it might not be BK, well, that's just opening the wounds for them. But I understand that, but it's not fair for
that's all they can do.
Right.
That's all they can do. All they can do is put all their trust in the people that are hired to do the job, because where else can they put their hope? There's nowhere else.
Exactly. But then later on, let's just say he gets convicted, and then later on they find evidence that he didn't do it. Imagine the guilt and stuff, and the anger that the families are going to have to go through, opening this whole thing. Then you may have another suspect. You may have the real perpetrator at some time, and then they're going to have to go through all of this again. And that's not fair to anybody's family or to BK or whatever. Like, it's just like I keep saying in all these other cases, let's get it right the first time. Okay?
Yeah, because they never truly get justice. How are you supposed to get justice? How are you supposed to get justice if somebody's let off? You really think they're going to find the right person that did the crime if this person gets off 10 or 15 years later because of evidence? Then the family never gets.
I don't think they care because they'll never go back. They'll never go back. They're in too far on Brian, and they'll never. They're stuck.
All their chips. Yeah, they pushed all their chips in. They don't have any chips left. They're at the poker table and they're waiting till they gotta put their cards down on the table.
And that's when the jury
that's when the jury.
I still say that it's going to go down. Like I said, he's going to get found guilty because it's not going to be a fair trial, and it's going to end up in appeal court. And he's at some point he's going to be found not guilty, and they're not going to go after the real perpetrators of this case. No. They won't. They won't because it will prove that they did a messed up job.
Yeah. And then imagine if they admitted that they're going to look at other leads, then the university is back to day one, Tommy. The university is back to day one.
Yeah.
There's you threw all of that progress away at that point. If that's why they won't ever admit it, even if BK does get off. I'm interested. I'm intrigued that you think he's going to be found guilty. I kind of think he's not because I don't think there's going to be enough to prove it. But I'm
worried about the jury. I'm worried about the jury. I'm worried about Idaho because
I have a question for you
investigating guys. Investigating that place gives me the chills.
Well, what's your question, Forensic?
I'm actually interested in hearing your opinions on this. If they don't have the information that they said that they had, then what did they present to the grand jury as probable cause?
The Christmas stocking with crumpled up paper that they provided for the PCA to get the arrest of BK.
You think that's like literally all of it? Just what we know is just what they Well, wait a minute, because for me, looking at the paperwork and actually imagining like the presentation of what they say they have in that paperwork, in fairness, according to Anne, she does not have any of it. And she's saying that she doesn't think she has it because she doesn't think that they have it. Right? Yeah. If you don't have it, how did you present it?
You know, what if it doesn't even exist?
Did you present just the statement? So
the same thing,
did you present just the statement of Brett Payne and Dustin Blaker and say, this is your story, and no one in there said to you like, "Where's a picture? Where's a?"
The answer to your question.
That's what they said. I think that's what they said. All they had to do was walk in with a piece of paper that
so you think that's the issue from the 6 jurors?
I think no. I said I think they wanted a picture of the car because that's the easiest thing for the jurors to understand is seeing a photo. Because really, if we look at the PCA, wouldn't a photo, if we're looking at it, cast data, that's going to be papers and papers.
See, I think that the 6 jurors had questions because they were not given much more than the stupid statement.
Yeah.
You have to remember that an indictment. You have to remember that an indictment does not have any cross-examination. The 5 of us, 1, 2, 3, 4, 5, we've had a year and a couple of months to digest all of this and think about all of this and analyze all this. An indictment, remember, in an indictment, the only person that is there arguing the case is the prosecutor. There is no defense attorney. Brian Kohlberger's attorney was not allowed to be there. There's an old saying in criminal law 101,
I'm hungry.
Procedure 101 in law school. You can indict a ham sandwich because you can take limited evidence, not even, a portion. You can take limited evidence and argue it and indict a ham sandwich. And so It's stupid, but it's the law. And that's why a lot of jurisdictions are now going to preliminary hearings. And that's also why the prosecution in Idaho wanted to circumvent the preliminary hearing and go with the indictment because it's easier. It's the easier route legally.
Well, I'm going.
There is no argument.
I was asking because I'm actually going with they didn't have it then. They don't have it now. They won't have it in the future.
That may be.
That's
right. That's why I think.
I think what happened is,
that's why I think he's going to be off.
I still think that the police brought Thompson what they had and promised him more, and they couldn't get more. That's what I think. That's why
my dog wants to go back. I'll check in with you guys later. But my dog is wanting to go out, and I better let her out.
All right, thank you.
I might be in the same situation over here, guys. So I'm probably going to have to get out of here too.
Oh, I appreciate you, and I totally agreed. I think they wanted a picture.
Me.
Oh, thank you so much. Thank you for being up here. Anytime you want to, please reach out. You're more than welcome.
Nice to meet you.
Very nice to meet you too, as well, Silky. Nice to see you, Tommy, and I appreciate being here, guys. Have a good night, Andrew. Good night, Evil CJ. Everyone, thank you for having me. Yep. Thank you for all your nice comments, and I do look forward to returning again.
Yeah, thank you so much. Right. Appreciate you so much.
Good night, guys.
Good night.
Good night.
I totally agree with her. I think they wanted a photo. I think they wanted a photo of the vehicle, and it was as simple as that. Hey, can we just see the photo? We got all this other stuff, which all they really needed, like Andrew says, they just needed the same piece of paper that we've been reading this whole time, called the Exhibit A, Brett Payne of the affidavit.
Right.
And that's all they needed. What doesn't show? There's a picture of the route. There's a picture of the route that he left. But when it comes to the car, you say, yeah, I got video here, video here, video here, video here, video here, video here. Well, can we see the picture? And it'd be something as simple as, well, you should already have the picture. It shouldn't be hard to offer the picture, and it would be very easy to understand the picture. And I think that's all they needed, or was questioning, was, okay, can we at least see the picture? And they didn't have it, because I don't think they have it. And I think that's why Ann Taylor ain't getting it, because they just don't have even the photo to show that, which you should, because like this background right here, I'm driving the route.
Well, they have video. They could always take a screenshot of the video. And
that's what I'm saying. Like I'm driving here. The cameras are crazy. Tommy, you look up the street cameras of Moscow. If you want the link, let me know. You got the street cameras of Moscow, Pullman. Dude, clear as shit. You can see the difference in the shadow on a vehicle when it comes to the aerodynamics of the certain parts, of the body and stuff. They're so clear. They're so clear. And you're talking about the most well-lit areas anywhere, because they're at intersections of busy streets. So you don't have a lighting issue.
What you're saying then is they probably got his car. I mean, if it's then you're saying they got his car, correct?
No. I'm saying they don't have a picture of it.
Okay.
Right.
I'm saying they were waiting for evidence to materialize.
Right.
And it never has.
They should be able to take a picture, a screenshot. Right.
Mm-hmm. And when
Ann Taylor keeps saying there is no connection to him in that house.
She can't find it. Even the video. And that's
and there's how many white Celantras and or Elantras, I mean,
Dude, there's so many white vehicles, period. I mean, you can see in this footage. Look at all the white vehicles.
Right.
I mean, they're all over the place.
Yeah.
All over. Yeah. So,
and I mean, you've got the car. Okay, you don't have the photo. You've got him in the general vicinity at different times. But look, when it comes to trial and stuff, you saw, just like your incel theory, you're assuming that the person came by car, but they didn't have to come by car. I mean, that's just one theory. And that, I don't think there's going to be enough with that sheath and the IgG. I think they're going to tear that apart. I mean, could he be convicted? Maybe if there's more evidence, but at this point, I think they're going to poke holes in everything. And the fact that there are so many people, it was dark. There's a lot of other suspects, really, if you want to look at it. And all she has to do is, you know, so you're trying to tie somebody with no blood evidence. You don't have a whole lot of anything. Even if you had his car there, that doesn't say that he went into that house and did that.
Well, let me ask you a devil's advocate question, and that is, Ann Taylor said that she has 250 items in discovery, 13,000 photographs, police reports. Do you think that prosecution has stuff that they just haven't shown their hand? Do you think that they have the evidence that's going to convict him? What is all this stuff she says that she does have? What is it?
It's probably scattered like she has it scattered. They have probably way too, they probably have so much that they're even having an issue.
Yeah, I mean, they could, and if he's guilty, I hope they do. I mean, I hope if he's guilty, they put him under the jail.
Yeah.
But I mean, I don't have a dog in this fight, but I just feel like, unless they have evidence, all this stuff is it going to be circumstantial? Because I know they don't have to put all of the stuff or even the best stuff in the PCA, but you would think that unless they just, after the PCA, did they come upon some, very incriminating evidence? Maybe. And if they did, and it's in that pile, then that'll come out. Otherwise, it seems like to me it would be circumstantial.
Circumstantial evidence convicts a lot of people. There's a lot of people use the word circumstantial as though it's derogatory. It's not, and jurors are given a specific instruction that tells them that circumstantial evidence is direct evidence, and they can use it to convict. So I'm just wondering, with all this stuff that's out there, and with the gag order, the non-dissemination order, and the sealing everything, if the prosecution said they were ready, willing, and able to go in January, in June. So I'm just wondering if they have it. If they have the stuff, they're just not showing us their hand.
They're probably just like the whole process has been, from the get-go. We're just going off this. We were able to be successful getting the arrest. We're going off this. We're able to be successful with the indictment. We're just gonna go off this and we'll roll them dice. I don't think they really care. I don't think they really care, because if they did, why wouldn't the DNA is the most damning evidence that
it's going to be appealed anyway.
Why wouldn't that be protected?
Just get appealed anyway?
Why wouldn't that be protected? It's the most damning evidence.
Aren't death penalty cases automatically appealed anyway?
Yes. Usually, yeah.
Mm-hmm.
Mr. Myers, let me ask you this, because you said, and I understand for sure people get convicted on circumstantial evidence, but in your experience, when it comes to a potential death penalty case or something, life without whatever, does circumstantial evidence have less? Does it weigh less in those circumstances because of the enormity of the sentence?
Because this issue is raised all the time. In one of my previous episodes that I did, I read the Idaho jury instructions. They're online. The standard Idaho jury instructions are online, and I found the one on circumstantial evidence, and it specifically, the judge tells the jury that circumstantial evidence is evidence, and if you can derive logical and reasonable inferences from that evidence, you're to use that evidence. So think about it. How many times in a murder case are you going to get a videotape of, okay, I'm going to shoot the guy? No, it's almost always 99.9%, if not more, circumstantial. So that's not a pejorative word. Circumstantial evidence is evidence for the jury to consider. Now, what weight do they give it? That's a whole nother question. What weight do they give it?
Yeah, I'm just thinking, if I was on a jury, I would, but that's just me personally. I would want to see something, a lot meatier before I would, say, yeah, he's guilty. beyond a reasonable doubt.
Well, they're not. Oh, for a regular jury, yeah, for sure. Yeah, that's why I feel like I'm not so sure that he's. Maybe they were able to slide through with that Christmas stocking in different areas leading up, but when it comes to the trial and the jury, I think that's when it's going to be exposed that it's just crumpled up paper mostly.
Well, we don't know.
Yeah, that's why I kind of feel like they're
But
gonna.
then again,
they're gonna battle it.
CJ, I mean, if the jury is, from that area, the culture, you have to take into consideration the culture and everything that they believe. Their mindset. They're not looking at it like you and I are looking at it from broad spectrum. What happens, and like, it's this little town. It's got to be that stranger. It certainly wouldn't be any of our people.
Yeah, but when you got experts, that's the part where experts come in. And that's what I'm saying. Even if, because Steve G said, whether it's true or not, Steve G said that what they want for the potential juror pool is farmers that have no idea what's even going on or heard about it, right? So that's where the experts come in. It may be, yes, they may be from a small town, they may be interconnected or whatever. But at the same time, that's where the experts come in, and that's where it's up to the experts, and that's where I feel like he has a chance, is because I feel like the experts, whether it's us that have watched all these people, on these true crime shows, and these experts talk already, because we've all put in a lot more hours than this jury will learning about the DNA and stuff like that.
Right.
It's up to that expert, and I think the experts, because of how shoddy all this stuff is, I think the experts are going to have a success of being able to battle all of the information that maybe the jury doesn't even understand or know.
Yeah, I mean, I agree with that part of it, CJ, that if you take farmers who haven't heard about this case, they don't know about DNA, they don't know how this works. Yeah, on that part, I feel like could sway a whole lot. On the other part, just being raised and living in a small town, I think you have a whole other gray area where
you only need one.
That's true. And I just look at historically, small towns. I mean, especially here in the South. I don't know how it is in Idaho, but you were guilty if your neighbor said you were guilty, or the church or the whatever group that you're guilty, because that's the way it is.
Right? Were they as publicized as Idaho4?
No, but I mean,
that's
no,
where
of course not.
That's where it comes in too. These people are under microscopes. Everybody's under these witnesses. Everybody's going to see these witnesses. These experts.
I can't wait.
Everybody in the world is going to be. So maybe in a small, and trust me, I understand what you're saying, and I'm not disagreeing. What I mean is, this is on a way another level that it goes beyond that, because these experts already are going to be coming in with the best arguments that they can have, because they already know that this can even be a make or break for their career. Look at Chris Darden and what happened to him, after the OJ case.
Yeah.
He went totally downhill. So, and it only takes one.
I hope the jury is open-minded. I really do, because like I said, I just want, the truth. I want, the right guy, the right conviction the first time. I just hope, because, when they're in that jury room, they're not seeing, once they're, sequestered, they're not seeing all of the comments. They're not seeing, the big, mainstream media talks about, what happened.
You want them to see that?
No.
See that?
No.
Want them to see that stuff.
No, I don't.
The evidence. That's all.
No. Yeah, but that's why I'm saying they're going to be sequestered, and they're not going to see all this till after. So that's where I'm hoping that a small town mindset doesn't play too much that they can get beyond that.
Think about it like this. We'll talk about CAS data, for example. I don't even know shit about CAS data. Maybe they won't, right? When it comes to CAS data and you don't have all the information like Ann Taylor's stating, then how can you say that you got this guy pinging? Because that defense expert can say, okay, witness expert for the prosecution, you're saying that you pinpointed BK based off of cell phone data. Are you saying for certain that my client wasn't 32 blocks away from where you saying he was at? Can you say for certain? Well, no, I can't. That's what I'm saying. That it doesn't matter if it's going to be closed town or not, because that defense expert already said, I already showed that my client could have been 32 blocks away from where you're saying his cell phone pinged him at a location. And that right there is what I'm meaning by the expert witnesses. And it.
Well, I sure hope you get. The main thing is I hope he gets a fair trial there, and if he does get a fair trial, he'll get released, because there's just from the evidence that we're showing right now, they have nothing.
Right.
And doesn't even have it.
I hope they don't have the same problem, though. That you were talking about OJ. I hope they don't have the same problem with this new IgG stuff and touch DNA, because I don't think OJ would have gotten off today the way that we understand DNA. But I hope this is not going to be such a problem.
But that would have been blood, and that would have been more than touch DNA.
Right.
This right here.
But see, that's what I'm saying. If they don't understand it the way that people didn't understand OJ back in the day,
they don't need to, though. They don't need to, because when it comes to the defense is going to tear holes in that more than they'll tear holes in the CAS data.
Yeah, they sure will.
Yeah.
So
is there going to be?
That's why I feel.
I thought that car didn't do that.
Well, I mean, that's according to, it's all about CAS data. That's what it's all been about, was this CAS data. That's one of the things she was referring to, and that's supposedly supposed to pinpoint it closer. But any defense, criminal defense, even Scott Reich has said, yo, you could easily say my client was 28 to 32 blocks away, and they can't argue that they weren't, because there's nothing that we know. Now, maybe the FBI has some technology, and that's another thing. Maybe they're not releasing this CAS data because it might be technology that they don't want out there. That could be another thing too. It could be technology that they don't want out there when it comes to this CAS data, and maybe that's why they don't have part of it. But when it comes to blowing holes in whatever part of the defense, I don't know. I just think that they're going to blow holes in the DNA more than anything. And that's just I think it's going to be it's going to be junk, and they're going to have to rely on CAS data in the video footage.
That's all
you can show video, if you can show video and you can show CAS data, then you can say, well, that's got to be the weapon, and
Yeah.
But we don't know. We don't know. We don't know what they have. We don't know what else there might be that's out there. They were so confident that they were going to go forward with a trial in June of 2020.
Ain't that crazy?
So there may be a smoking gun that we don't know about. There may be something like that.
Yeah, they
just want him to drop that speedy trial thing.
I mean,
I still think he should have went with that, because they have nothing.
I don't agree that they have nothing. We don't know what they have. Maybe you might be right. We don't know that. We don't know what they have. We have no idea what they have.
We just know what Ann Taylor don't have, and I don't know. I feel like that's telling if she's claiming she don't have certain things that I think that
she would have had.
That you would, that maybe you would. I would think.
I'll put it this way: things are looking like they don't have anything. That's the way I should word it. Because,
because we don't. None of us.
It just doesn't look like they have.
Yeah, we don't.
Right.
Ann Taylor herself has.
But who knows? They could.
Ann Taylor herself has admitted that she hasn't had time to go through all the stuff.
Yeah.
The 51 terabyte, she might have some stuff in there that we don't know about that croaks her client. We don't know. She said she has 51 terabytes of information and broke it all down and said that she has been spending full time on this case, and she still doesn't know. We don't know. We don't know that they don't have evidence that'll croak the guy. We don't know that. People keep saying that. You know, there's a YouTuber who's out there that says, "Well, they don't have anything on him." Well, we don't know what they have, but they don't have anything on him. Well, I disagree with that. We don't know what we have, so maybe they do have what's going to.
Yeah, I always leave that. I always have an open mind to anything and everything.
Well, it's a box of
from what I see right now. If I had to go, if I was on jury right now today, I could not prosecute him. I could. I could not find him guilty. No,
we don't know. We don't know what they have. We just don't know what they have.
That's true. Yeah, it's true.
Well, anyhow,
with that, I think I'm going to head out here, CJ.
I'm going to bid you guys adieu. I'm going to say good night. Thank you very much for inviting
me too.
Thank you.
Yeah, nice to meet you.
Nice to meet you, Andrew. Yeah,
thank you. Appreciate you.
Have a good one.
Very much.
Okay,
you too, buddy. Thank you. And great videos that you put out too.
Thank you.
Yeah, they're awesome.
Especially the last
every one of them.
Yeah, especially that last one.
They're really good. Yeah,
from today.
I think I'm going to head out too, CJ. And thank you for having me on.
Yeah, no, thank you. Appreciate it as always, man. Yep. And definitely enjoyed it, man. And we'll have to do it again sometime.
All right, good seeing you, Forensic and Silky. Is it?
Yes.
Silky Southern Tea. I'll be dropping everybody's link in chat again.
Okay. Good to meet you, Crime Time.
Yeah, good to meet you. Rock and roll.
Rock on, buddy. Thank you. Appreciate you. And I'll drop everybody's links up there. Now it's only 8:30 for me, so I've already said we'd be doing an extended show, so you guys are more than welcome. Would you guys like to watch this this court hearing again and just kind of go through it, or is there something else you guys would like to discuss? Okay.
Doesn't matter to me. I've got a little while before I have to leave.
Okay. Yeah, I'll be late nighting it tonight. So let me see here.
I've got to get up really early, but I can stay for a while.
Let's do this. Let's go ahead and get this like that. All right. So we'll go ahead and play the court hearing here. And do me a favor, community. I'm gonna I have a vote up a poll up right now. 80 votes. And it looks like Idaho4 is 53, Kansas City 3 is 35, and Scott Peterson is with 13% for tomorrow night's show. So if you want to go ahead and vote, please do. And let me get to the full live court hearing. Now, if you want this video for your playlist, here's the link to this. And StreamYard doesn't let me choose where I go. So this is how it is. All right, so we'll play the court hearing here. Give me 1 second. I got to get it off my footage. All right, we'll check out this court hearing. Anytime either one of you want me to pause it, and thank you for hopping back up here, Forensic. Anytime either you want me to pause it, let me know. We'll pause it. We'll discuss something if you want to discuss something. And then if not, what I plan on doing is I'll just go ahead and pause it after Logston speaks. And then we can pause it after Thompson speaks. And we can pause it after the judge speaks. Or at any time that either of you would like to pause it, just let me know. And then we'll go ahead and pause it. All right, so this is the court hearing from yesterday. If you'd like to have it, the link's in chat, and this doesn't have any of the other stuff, no discussion, and nothing popping up on the screen. It's just the court hearing. Oops, 1 second.
Great. All right, thank you. Let's get on the record, please. Okay, we are on the record. This is State of Idaho versus Brian Koberger, case number CR 29222805. We have Ms. Taylor, Ms. Logston, and Ms. Massa Representing Mr. Koberger, Ms. Mathis is remote. Mr. Koberger obviously is in the courtroom. The state is represented by Mr. Thompson, Ms. Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court, I guess, website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Koberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston.
All right, so I'm going to pause it real quick and let me flip the music back on. So, do you think he's just arguing what he was arguing in the court hearing in early November, where he was, like you were stating earlier, Forensic, he was arguing beyond a reasonable doubt for a grand jury, but really all they need is probable cause? What else would he be arguing?
I actually think that is all that he's arguing there, unless he's helping her with arguing what we didn't get to see because it was held in private. I think as far as this goes, he doesn't have anything else that he's actually arguing. I think all that he's saying is that, yes, the precedent has been set forth for it to be beyond a reasonable doubt, but for the purpose that we are going to, or I'm sorry, for it to be probable cause, but for the purpose that we are going to execute this man, maybe it should be more. So I see where he's coming from with his argument. I just don't see how he's going to get anyone else to actually feel like, okay, despite all of what we've done for the past 30, 40 years, as he said himself, now we need to change things, because then you have to go back and retrospectively correct things that can still be corrected from the past as well. So I think he's asking for a lot in this one argument for this one defendant that would then ricochet out into the world in a million different ways. I think he's actually asking for so much more than he realizes. And he states it like it's just like some simple request. Like, well, you know, so that's just my opinion.
Yeah, yeah, when it comes to like needing more, but really they don't, because it's just a grand jury, you know, they don't need much. And so I don't even know who would even, I'm surprised Dan Taylor, I don't know. Maybe it's part of her just letting him get some of the other stuff out of the way for appeal in the future. I don't understand what other, you know, why are you, to me, it'd be like, why are you wasting the court's time arguing something that really, how much weight does it have except for an appellate in the future, appeal in the future?
And I suppose that maybe even if the appeal that they asked for now is, you know, obviously was denied, but just because it was denied now, I suppose that at least presenting this argument at this point could affect an appeal that they may get down the road.
Future. Yeah, in the future.
Okay.
What do you think, Silky? You think that that's what it is? Is this just something to kind of make sure they dot their I's and cross their T's, so that way in the future there is a better setup for an appeal? Or
I mean, yeah, that's kind of what I'm getting from it. I mean, who really knows the motivation? But I mean, you would think.
Because how can you argue that a grand jury needs beyond a reasonable doubt when what grand jury has needed beyond a reasonable doubt?
Yeah. Right? I mean, no.
In the history.
Right. I mean, my understanding of the grand jury is it's just, do we have enough to bring this to trial? And, you know, it's not beyond a reasonable doubt. It's just, do you have any evidence at all that we can try this guy? Yeah. Yes or no?
Yeah, it's interesting. And then, you know, we got Mr. Thompson, you know, he wants to school Jay, so we'll hear that part next.
Mr. Nye?
Everybody.
Thank you, Your Honor.
Everybody.
I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today.
Man, I can't imagine.
We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case. It's the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logston? Reply.
Judge, once again.
Okay, and I'm going to go ahead and pause it here real quick. I think it would be damn hard to have beyond reasonable doubt to a grand jury.
Yeah. I mean,
That
you'd
would be
practically
hard.
have to, you'd have to do practically the whole trial. I mean, I think that's ridiculous.
And then to try and have, can you imagine all the criminals that would get probably able to commit more crimes because you need beyond reasonable doubt. That would be so tough. It would be so tough.
Yeah. I don't really understand it. I mean, that's never, like I said, that's never been my understanding.
Even if they wanted a picture of the car, I mean, still, even though they could have it, they don't need to, because they didn't need to apprehend him in the first place. So, to try and say that that's the reason why the indictment, because they wanted more evidence, they didn't have to agree with it. You know?
Right. And I think, just my personal opinion, but I think that they thought, or they're thinking that the DNA evidence is going to hold more weight than it probably will.
Mm-hmm. I believe so too. Uh-oh, your mic, something's wrong with it.
Oh, sorry, hon. I actually think that Ann Taylor's goal right now might be to go backward in time. So right now, because of the indictment, we're moving forward to the trial. But if we go backward in time without the indictment and I can get the preliminary hearing, my intent then is to argue with your experts. And right now, we just heard from her yesterday that it doesn't appear the experts, the cast members, the FBI analyst, it doesn't seem like all of the pieces are actually there. So I think she's trying to go back in time to the preliminary hearing, not just because she wants people to know what Bethany had to say, but because she wants the prosecution to have to come forth right now with whatever it is that they do and don't have, because that will put her in a better light for the preliminary hearing.
Right. Yeah. For them to show that they don't have anything, you know.
Yes. Yes.
100.
For her to take them backward to the preliminary hearing, and her experts and their experts really go at it. And then imagine that the missing pieces of what she says she doesn't have from them, perhaps maybe some of that she actually does have from her own experts.
Mm-hmm.
You know
And
what I
she
mean?
don't even, she even said, and that's even experts I don't even know who I have to get yet, because she doesn't have, I mean, to me, that was another telling sign too. She doesn't have everything she needs, because she's like, I know that there's supposed to be more there, and I know that I'm going to need an expert for what's supposed to be there, but I don't even know what kind of expert I'm going to need, because I don't know what's on the stuff that's supposed to be there.
Yes. And then she did also mention experts that will work with them.
Right.
So that is another issue that she is having, is finding experts who are even willing to put their name on the line to fight for Kohberger, aside from,
or even commit to a date that they don't even know exists yet too. That's another thing,
Sure.
Because they have jobs too, and they have to make sure that they can schedule this or that to even be available. So it's just a pickle, because there's not even maybe once a date gets set for a trial, maybe they'll be able to start collecting more experts. But man, it's got to be a pickle that they're in. And like she said, in the court hearing, it'll come up here too. They've only talked to less than 10% of the witnesses that they know about, and that's because most of them are just shutting the door on them.
Yeah. And now I want a pickle, because you said it twice. And I'm like, oh, that sounds good.
At least in the real footage, you guys didn't notice the A&W, because it always comes up. And man, I'm telling you, if anybody goes to Moscow, go to the A&W. It was the best food I had the whole trip.
Wow.
Yeah, it really was. All right, so let's see what Loxton has to say again. Why is he wearing such a long coat in court? Everybody else isn't. He must have been freezing. He's wearing a trench coat or something, Look
it's
at
the
him.
drama. It's the drama.
That's what I noticed.
It is.
I'm like, what's up with the coat looking like Fetterman and shit? But instead of a hoodie, it's a coat. All right.
We believe this to be an important issue, and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. as the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Wow.
Excuse me.
That's a little immature, though.
Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. And as I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, I'm going to deny the permissive nature. Yes. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood of possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position on...
Okay, and we'll go ahead and pause it there. Now, when I meant by saying it was immature, I think it's immature for a lawyer to stand up there in front of a judge in a court to say, the prosecution's trying to kill somebody. There's a respect. You're supposed to be about respect in the courtroom. There's a respectful way, just like you don't go to a boardroom business meeting and say this Sprite tastes like shit. I'm just saying, you don't do it. So that's why I said. So that's why I said it was immature for Logston to say that. He could have said it in a different way. And I don't see how there could ever be a difference of opinion when you're arguing probable cause to beyond a reasonable doubt. So I think that's why Ann Taylor said, no, Your Honor, thank you, was because they really, what else are you going to argue?
I think you're right. And I think that as far as the difference of opinion thing goes, like after he had stated how many years, Jay logs in, how many years he feels like this has been the thing and that it should be changed. I guess after 30, 40 years, actually how he said it was 20, 30, 40, but I guess after 20 to 40 years, if you are the person who has a difference of opinion, then maybe you're just difficult. You know, like maybe I don't know. I don't know. I'm just saying. But as far as like this being exceptional, I don't see it as exceptional either. However, I totally disagree with the judge. And at this point, I guess as far as this goes, I do agree with Ann Taylor that this actually could potentially advance the case and not cause unnecessary delay if the Supreme Court did, for some reason, dismiss the grand jury indictment.
Right, right.
Like, if she took this to the Supreme Court and her goal was met, then don't we go backward? Doesn't she get her
Right.
preliminary hearing? Can't she
Yep.
argue things differently a few weeks from then? Can't her client be walking out of there if that's
Right.
so happens to be how it, plays out? So then technically, I think that he just was really forecasting a reasonably forecastable delay, but only if you look at it from his side of things. If you look
Right.
at it from Ann's, I don't think that she sees this as potentially causing some kind of delay that doesn't need to be caused. She sees this as this is actually literally the means to the end. Like
Right. Something
this is
that could
how we
set my
can get
client
there.
free.
This could, you are delaying my client being able to go free
Right.
by
Right.
refusing my client this.
Right.
So I actually disagree with him there, although I do understand where he's coming from. I just
Well-
don't think that he's looking at the other side of the coin.
I think this is, and anybody that knows, correct me if I'm wrong, but I think they needed to get the judge, if they are going to go to the Idaho Supreme Court, I think that they needed to get the judge to deny the reconsideration for them to be able to go to the Idaho Supreme Court with that issue. And so maybe that they already knew, maybe before they started bringing this up, they already knew maybe they have close enough to meet the standard of what it would take for an Idaho Supreme Court to rule in their favor. And so they're just doing the necessary steps to get the denials from the judge to then be able to say, look, we brought it to the judge. He denied it the first time. We asked him to reconsider. He denied it the second time. Now we get to bring it to you. You decide. Maybe that might be what they're doing. And maybe it's not necessarily arguing stuff that we think is a wasted argument, but maybe like what you're saying, Forensic, maybe they really do feel like they might have something that instead of it delaying the trial, you're just delaying the time that my client gets to get set free. And once the grand jury sees that there is, so what about the preliminary? Yeah, we go back to the preliminary and then we really truly decide what should actually be the right way to the path of truth and justice. Because if there is something that was amok with the indictment, well, because really they went off the PCA. If she doesn't have things that are collaborating with the PCA that, according to the prosecution, puts BK there in all these other different ways, and she doesn't have it, well, then is the PCA that they brought to the grand jury really the actual evidence that they needed to then go ahead and indict? I mean, I don't know. It just, because there's the process, and it's just like whenever you have an issue, say you got an issue with the manager, well, you need to go to the assistant manager. There's a hierarchy or things or steps that you're supposed to do in order to make sure that everything's done the proper way, protocols and procedures.
Yes.
Maybe that might
And
be it.
reaching out to this judge is actually the thing that she's supposed to do. The check and balance for this is, in fact, because I did hear other creators that were actually, you know, like they were a little perplexed by this. The check and balance for having to ask the judge for permission to go above his head is that someone above his head can always chop his head off.
Right. And
so you don't need his permission at all if the Supreme Court has enough interest in what's going on here. If the Supreme Court so happened, my father-in-law is a New York State Supreme Court judge. So if this were in our state and he were to just be listening to me, listening to this, and think that this was something that he was interested in changing, then he technically could. He doesn't need anyone's permission to get involved or any of that stuff, or, you know, so I think that that's something that the judge was also trying to make very clear, is that if there's anyone at the Supreme Court level at all that right here, right now thinks that I'm making the wrong decision, they can do something about it. And if they don't, then maybe this isn't worth you taking to the Supreme Court.
Yeah. Or it could be a scare tactic to the defense to say, don't even try it. You know?
Yes.
I don't want you to overrule me, because I don't see why. This is why we all thought it was going to get denied for the reconsider, because what judge is going to say, okay, guys, I fucked up, you know?
Right.
Usually they're just going to be like, no, I made the right decision. This is the way it is. And I definitely could see him having a major temper tantrum if it did make it to the Supreme Court and somebody did make a ruling on it. You know, he'd have a freaking fit if he was overruled. So I could see him also trying to scare the defense away. Like, look, you know, you can do this if you want, but, you know, we'll see. Who knows? All right, so they're going to get to unless you guys want to add anything more, I'm going to go ahead and play the part where they get to the scheduling now with their arguments. And I think Ann Taylor really starts knocking it out of the park here too.
Scheduling. Yes, sir. I'd be happy to. And to start, Mr. Logden said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, it's just simply appealing to raw emotion, and it has no place in this court. We would ask that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School. The chair's parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Taylor.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Koberger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, the court knows everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have 1 of those. So 500 hours times 51, or 6.5 million document pages.
And that's what I wanted to say from earlier. This is 1 terabyte. This is just one. 650,000 documents. 500 hours of video. That's why I'm saying when it comes to the 51 terabytes, I'm going to always say the majority of it is the video footage. It's no lie. My footage alone from Moscow and Pullman is almost, like, it's crazy. It's almost a terabyte just from my trip to Moscow and Pullman. So they probably, instead of, giving them the videos that they are supposedly going off of the PCA to say that BK was here and here and here, the whole how I came up with the route, they probably just gave him a huge data dump, and they're trying to figure out, like Ann Taylor said, thank you, Forensic. I appreciate you so much. Thank you for hopping back up. Like when it comes to the data dump and the video footage, I'm sure there's plenty more than 500 hours. They probably, even though there was a focus on maybe 10 minutes or 2 minutes of a certain part, okay, they probably gave them the whole freaking video. So they got to go through not only all the video, but then all the other video that they claim to have, because I'm pretty sure the couple days they were trying to collect every video, whether it was street or residence. And it's got to be, how many? 650,000 documents for 1 terabyte.
Wow.
How many documents would there be? I know there's an abundant amount of documents, but really to add up to 51 terabytes, take 650,000 times 51. And that's how many documents it would be. There's no possible way. It's got to be majority of video footage.
Yeah, that's crazy.
650,000 documents.
And and when you're talking about video footage and stuff like that, and even something written, it's not just like, oh, I have to watch this. Like, you have to really look at it second by second, analyze everything, see what somebody may have missed, or think about the stuff that we've done, CJ, and the
I think editing. Like for a 10 or 15 minute video, it would be like that. Like the amount of time it takes us to edit a 10 or 15 minute video could be an hour or 2 hours.
Absolutely.
So
for me, it's way more. Yeah.
You're taking a 10-minute part of a video. You're trying to analyze if it's really evidence or not. And it's that 10 minutes is 2 or 3 or 4 hours. Mm-hmm. I can't imagine trying to go through all of that footage. What's up, Rosie? Hope you're doing okay. Yeah, it's just the abundance. That's what I don't think they didn't give them anything. I only think they're not giving them the stuff that they just don't have, and it's the material. Part of it is the evidence that never materialized, and they have egg on their face. And what are they supposed to do but say, "We gave you everything"? You know,
Right.
they're not going to say, "Well, we were expecting more than what we," but they're not going to say that. They're going to be like, "Hey, I gave you everything."
Yeah.
There's all the books.
And it makes me wonder, like, how much of that is actually good for anything? Or are they giving that many terabytes of evidence to make it more difficult, to make it take longer? You know what I'm saying? Is it because it's actual evidence, or is it just because, we know that they're going to be so busy with this that they're going to miss something?
Mm-hmm.
You have to wonder.
Yeah, I don't know. After this court hearing, I'm just like, they don't even have what they thought they were going to have. It don't even, because how in the if they had everything, like they're going to be ready in like 2 or 3 months, 4 months to go to trial, even if you have I think they're like, you know what? We were expecting this evidence to materialize. It didn't. We said we have everything turned over. We really do, as far as what we have. And we're just going to have to roll the dice and go with what we got. We're already ready, Judge. Why would we want to give the defense any more time to try and put their case together when we have a lackluster on our side and we just want to hurry up? It would be a benefit to us to have the trial ASAP if we were expecting evidence that didn't materialize, because then the longer that we wait means the more time the defense has to present a better case.
Right. I mean, yeah, you would think that. I mean, I would think if I were a prosecutor, that's what I would do. Honestly, I would wait till the last possible minute to turn over all the evidence, and I would try to get the trial set for a rushed time.
Yeah.
It's strategy. It's like a chess game, and
Yeah.
and that's really sad because, we're talking about justice. We're talking about people's lives. And, it should not be allowed to be that way. But, that's the way the courts do it. I think it's kind of a problem. But, it is what it is. And honestly, I don't think they can lose as far as, if Koberger walks, again, I think it's just like, well, the jury didn't see it our way. Case closed. Everybody's safe now. The house is down. Let's just go back to life as normal. And it's going to go into one of those things. If he gets convicted, yes. Will he appeal? Of course he will.
Of course.
And we could be looking at this. Like the same thing in Delphi that I said like a year ago. It doesn't matter if Richard Allen is, found guilty or not, because they're going to just say, okay, we're done. And that's exactly what they've done in the last week or so. They've said, oh, you know what? We're not looking for anybody else. They changed the charges, blah, blah, blah. It's a win-win for these small places, really.
Yeah, you got two drawings that look like two totally different people, and yeah, it's only one person. Okay.
Yeah, there's so much in that case, but it's the same thing. It's like at the end of the day, the university wants to make everybody feel safe. They want their enrollment up. Law enforcement wants to come out smelling like roses, saying, "Hey, we got your guy. I'm sorry that the jury didn't see it that way." That's all that matters. Everybody looks good. Everybody smells good, and to heck with the truth.
Well, and Jenny, this is why I said I think they just threw Payne to be the guy that would get all the shit thrown at him because of how shoddy it was, 2 years experience. And when you look at when you really study the PCA, what is the PCA, everybody? The PCA is people showing or telling Brett Payne something, right?
Mm-hmm.
So-and-so showed me this. So-and-so told me this. The only time that he came up with information himself was when he watched Nunez's body camera and then noticed there was a dog. Like, you didn't even notice there was a dog until you reviewed somebody's body camera. And why did you have to review somebody's body camera when you couldn't just talk to them? Probably because it was a rush job and you needed to be shown it before you could write the PCA.
Yeah.
Because somebody wasn't available at the last minute to talk to you about it. All they could do was watch a body cam of it and hurry up because they had to hurry up and write it. So look at really look. We're going to be going into it here in the near future. We're going to be digging into the PCA. We're going to have Commercial Zone back on the show, and we're going to be going. She did a lot of work digging through the PCA, and I want to highlight her work. And you guys will see. It's a lot of just being shown or being told. And so when you're being shown or you're being told, when it comes to the evidence, well, it just gets deflected to somebody else. It's a very interesting web. These guys this isn't their first rodeo. These guys are all stars when it comes to getting these cases constructed in the way that they're getting them instructed, because they know this is how they've gotten away with it before. This is small town. We just like Stephen Smith in South Carolina with the Murdaughs. It's generations. They perfect it, and then all of a sudden they ran into what South Carolina did with Stephen Smith. You're running into social media, and you're running into the new news, which is YouTube. And unfortunately, we're a lot different than MSM. We actually tell you the fucking truth. We actually do ask the questions, and we do try and report the truth 110% of the time. So that's why these communities now are getting exposed, is because we have all fucking day to dig into this shit. And
right.
We're about the truth. And if it's like if we're putting ourselves in somebody else's position, I would hope somebody would be out here saying these things as well.
Right. And that's the thing, CJ. Now I know that some creators are biased. They believe one way or another, and you're not going to change their mind. But in general, that's what we're doing. We don't have a personal dog in this fight.
No.
It's just like we're looking at evidence. We're asking these questions. We're digging. And I don't live in Idaho or Delphi. It doesn't matter to me. I could not
be talking
personally.
Cavaliers. I could be talking Cavaliers and Cowboys, baby.
Yeah.
I don't have to. If we're talking my true passion, yeah.
Right.
Cavaliers and Cowboys, baby. But no, this is, and I appreciate it, and it means a lot to me that I really do dedicate like every minute that I'm awake to this. I really do, whether it's work or thoughts or prep or any of that stuff, or even study, just whatever. It even just coming up with a thumbnail, it's just, so I don't mind it. I think because to me, it's like, you know what? If I'm sitting there talking about Cavaliers and Cowboys, and I have a voice, I have a platform on YouTube, why don't I use it for somebody else that really, really needs it?
Right.
So that's why I'll talk for hours and hours and hours about questions about, like Kansas City 3. How in the hell does 3 people end up, there's just, it's just, as a human, you don't want to see any victims not have justice, or any families not have justice, because if it was any of us or any of our family members, I would totally 150% appreciate anybody that is doing the stuff that we're doing. So
yeah, me too. Look, my passion wasn't current crime. It was telling stories, and not just crime stories, just telling, vintage stories and, paranormal stories and stuff like that. It was fun. It was fun for me. And that's the thing when you're doing stuff like this. If you do let's say you're talking Cowboys and Cavaliers. Now you're going to have some fans who are going to object and troll you, but whether you're doing that or whether you're doing, stories like me, nobody's really trolling you that hard. Nobody's threatening your life. Nobody's, really making you put yourself on the line. But when you start doing stuff like this, CJ, we both know there's a price to pay for this.
Yeah.
And, but a lot of creators,
you got to have the skin for it. You really do.
And you have to be willing to take a stand against corruption, against something that doesn't look right, call it out, investigate it. And I mean, it's.
Because there's people out there trying to silence you every minute of the day,
Yeah.
I
mean, it'd be a lot more fun and easy to do reaction videos,
Right? I know.
Yeah.
Just pop on for 10 or 15 minutes. But you know what? I love the platform. I love doing how I do it. I love doing the lives because, as much as I see, because let's be honest, a lot of true crime content creators out there, the ones that are getting a shit ton of views are the ones that are making the 10 or 15-minute videos, and that's totally fine. But I don't like to hold my community or my audience to a comment section that I might not even be able to react to on the fly or on the moment. I like being able, and this is why I do lives so much and why I dedicate my time to lives so much and not necessarily the short content, even though it would, be better. It's because I really do enjoy the community. I enjoy seeing your guys' messages as we're talking about these things and that's why I call it brain stew, because really we're all dipping our heads in the same pot and we're all stirring it together, and all of that is it's just too beautiful for me not to have or not to put all my energy in. So it's we get these we get there's certain things that come along with it, and you have to be prepared before you even really create a channel, because if not, you'll learn real damn quick.
For sure.
But it takes certain people. That's why we're here, because there's different factors that we're comfortable with or that we're able to do. And so if we are able to be behind a microphone and have a show and discuss things that maybe some people aren't even comfortable discussing, it's because we have the availability to do that, and we should do it just as another soul that's trying to push positive energy in anybody's direction, because the world doesn't have enough and we definitely need more of it. So why not contribute to that instead of the other?
Absolutely. And I just realized what time it is. I'm going to have to go, CJ, because I have to get up at dark 30 in the morning.
Oh, it's all good. It's all good. Thank you for hanging out tonight. I appreciate you and everybody else. If you're not subbed to Silky Southern Tea, definitely go check her out. Here's the link for her show. I'll go ahead and drop everybody else's link that was in here tonight.
Yeah, I'm going to have to check out some channels I've seen, some I haven't. I'll have to go back and look. If you are by chance watching from my channel or watching on the replay, jump over here to CJ so you can finish out this court hearing and see what was going on.
Yeah, thank you so much. I appreciate it. And it was a great night having everybody on here too.
Yes, it was. Thank you for having me, CJ.
Thank you, Silky. Appreciate you and everything you do for the community.
All right. I'll see y'all later. Good night, everybody.
There we go. Silky Southern Tea. Definitely go sub if you're not. All right, we're gonna get into this this part of the part of the hearing here. We're about a little past halfway through, and this is where they're gonna be discussing more of the scheduling and definitely go subscribe to all these people tonight. Thank you so much. Appreciate everybody. What a great night. And I think I might go hang out at the lounge afterwards. We'll see.
That's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team
400
have talked to less than 10%, well, less than 10% of those.
Over 400 witnesses, less than 10%. Crazy.
Witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Brian's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example.
So she's stated some examples. I want to say shout out True Crime Overtime with Rosie. She's joining us tonight. It's very early over there. Thank you so much.
Thank you so much for having me. And sorry I'm late.
Oh, you're fine. I know it's early for you. What time is it over there for you? Like 5 or 6 in the morning?
It's about 5:30. Yeah.
Right. So no, I'm sorry. Definitely we're going to have a show in the morning sometime. If you're not busy tomorrow, you're more than welcome to join me for an OJ25 members only that I'm doing, since you weren't able to join tonight, if you'd like to. That'll be noon. That'll be in about 14 hours from now. Well, shit, is it? Yeah.
I have armchair jet lag, but
I don't know. Yeah. But yeah, I'll reach out and we'll see, and just let me know. You're more than welcome. So thank you. I apologize it's so early over there. Yeah, but I'm glad you could join. Yeah, we're still going to be doing a show for a little bit longer, so I'm glad that you were still able to join, even as for the ending. So I'm going to go ahead and pause this for a minute, and I'm going to ask you a couple questions that I asked everybody else that we had up earlier in the show. You got a chance to watch the whole court hearing, right?
Yes.
Okay. What were the 2 wow moments to you that you took away from this court hearing that took place?
Well, look, I think Ann Taylor's comment about the PCA was obviously quite telling for a lot of us on YouTube, but also very validating in a way, because this is somebody who has access to more info than us, and she's talking about how while she's reading the PCA, she's kind of understanding their conclusions less and less. And I think that, for people who've been questioning the PCA for so long, that was validating in a way.
Right.
So I mean that it kind of helped us, or me at least as a YouTuber, to feel we're sort of on the right track in a way. But what I found really interesting was the way she was speaking about how she was receiving information from the state. And she was kind of implying that it was very disorganized. But at the same time, the state is pushing for things to go ahead faster, and it's kind of implying that they're ready to do this. But one has to wonder, how are they ready if they're working from the same info?
Mm-hmm.
So is it that they're ready because she's not, and the more ready she gets, the less ready they are, or are they actually ready?
Mm-hmm.
And I think that was very telling. How disorganized is it really, and how are they working with it? If that's the case.
When she's stating that they have stuff that they don't even have timestamps or dates, and these are crime scene photos.
Right.
Crime scene photos. How is that even possible? Very disorganized, just like the PCA, I think. And I agree with you. I feel it was like a validation kind of way, because when the judge asked her, or you'll hear it in a second here, he's going to ask her, like, how can we speed this up? And she's like, well, judge, this is the time it takes, and this is what we need. And when you hear everything that she does need still, I totally agree. Then I go back to how in the hell can the prosecution be ready for a spring 2024 trial? And that's why after that court hearing yesterday, I just came to the conclusion on my own that I think that they were expecting evidence to materialize and it didn't. And that's why they're just ready to go. Cause it's like, we thought we were going to have it. We don't. And we already put our chips in. We got to see what happens.
Yeah. I mean, it's almost like, do they prefer it like this? You know, this level of disorganization. If they're so eager to start, then what is driving that? If they're supposed to be working from the same evidence, it doesn't make a lot of sense to me.
If they handed over everything,
yeah,
you know.
But I mean, even what they have handed over, it doesn't seem like it's actually that easy to decipher. So, I mean, did they receive it like that, or did they, send it like that?
I think that's why I asked Andrew earlier. Andrew D. Myers, shout out again, law offices of Andrew D. Myers. I asked him. I was like, they could easily have had it in order, purposely tossed it all unorganized and said, "Here you go." And yeah, they could have, because it's a stall tactic. It takes them longer to get to their truth when you're closer to yours.
I think it's very diplomatic the way Ann Taylor is describing it and kind of trying to say, well, maybe they're in the same position as well. But I mean, between the lines, we don't know. And she doesn't know. So I think that she is conveying a little bit of a message there as well.
Yeah, I think with her saying what she doesn't have, I thought that was the most telling out of all of it. For this, I thought this was the best court hearing that they ever had. Is there anything else you want to add? Is there any other less than 10%, over 400 witnesses?
And I mean, Shane, if you think about the fact that people aren't wanting to speak to them, if that is the case, I think that, I mean, that is an added complication. But I mean, I think if it is the case, I still think it might have also been said like intentionally, because that will still reflect the jury, right? So she is kind of conveying that there is already an attitude just in her trying to speak to people. So selecting a jury, how is that going to differ? I think that's like an interesting point.
Yeah, especially the jury. I don't know. I hope they do a change of venue, because I was there. There's no way in hell, even if it's the summer, they'd be able to handle. There's not enough hotels, period, anyway. There's no way that they'd be able to, there's like 8 parking spots for the courthouse. You know what I'm saying? Like, for real. So I hope they do a change of venue. And I think that's I think, even though Ann Taylor says, I'm even nervous telling you, Judge, that we'd be ready by summer of 25, I think he's going to go in between. He's going to do the change of venue, and I think he's going to bump up when he wants the trial to start.
I mean, because if you look at the state, they're asking for not a year, but a time of year. So if he goes with the change of venue, then there's nothing really much they can say, because they can't be like, well, is there a university there?
Well, especially when they, that's, if they had the house, keep the jury local. You ain't got the house no more. There's no reason for the jury to even be in Moscow, because what do they need to be there for? There's no reason. And I hope Boise, I think would be a good place. They, like Bill Thompson even stated in this court hearing, Boise was like the one city in the very beginning that was constantly reporting on it. So he said it himself. They have an invested interest in this case already, and had for a long time. So I think it'd be a perfect spot to have it. But yeah, anything else from the court hearing? that you?
I wanted to ask you. I wanted to ask also Andrew Myers. With some of the stuff that Bill Thompson was saying about friends in going to Mexico and being asked about the case, and obviously saying that to him, does that interfere with the gag order at all? Because I'm not very familiar with U.S. law. So I'm not sure how it works, but it does sound to me like he was talking to his friends, and that just stood out to me. Like I wanted to know more about that.
Yeah, Yoli, are you in chat? That's an interesting question. I think that is a great question, because you would think that it would, but then at the same time, to expect somebody not, I don't know.
Because he's kind of saying that these people are speaking to him. He didn't say anything that he said, but I'm kind of curious about what conversation went on for that to come up. You know, like,
yeah, that's a good question.
Yeah.
Go ahead. At Yoli's in chat. Go ahead and ask that same exact question.
Okay. Well, do you want to wait until we get to where he says
go ahead.
it?
No, go ahead.
Okay. So he was speaking about his friends who went to Mexico and were telling him that people over there seem to know about the case as well, and people want to know about him being from Moscow, or his friends being from Moscow, and obviously for him to know that from a friend, it had to have been conveyed to him in some kind of a discussion. So I'm wondering, what are the parameters of the gag order if he's talking socially about how high profile this case is? If it's sort of a case of just people telling him stuff and he's just sitting there, I suppose he's not in the wrong. But if he's saying things that he heard, is that a cause for concern? Does that mean he's I don't know.
I would think it would be under the gag order, because then that would be like Enon going on a YouTube talk show talking about stuff. If he's under a gag order, then I don't think he's allowed to. Knowing about the case is okay. It's talking about the evidence. So yeah, if Enon was under a gag order and he went on to a YouTube show, then they would probably just get rid of him as a witness then, right? I would think.
So I mean, it's not evidence. It's just how
the evidence can't be discussed, right?
Okay. All right.
Right, the evidence. Yeah, that's a good question. No, really, because to me it does seem like it would be, but then maybe not. It just depends on the conversation. Yeah. So if he said like, what if I guess even if you said how many people were out there, that'd be considered evidence, because then you're stating how many people you saw out there. So I guess maybe your opinion, but not the evidence, even if it is stating how many people were out there.
Yeah. I mean, I suppose he's just commenting on
anything that's not released. Yeah. That's cool. Okay. Yeah, that's a good question, and thank you for asking. Let me see here. Let's get to this. And thank you again for hopping up. I appreciate you.
Thank you.
Well, Your Honor, that is not us saying we just don't want to go to trial. We just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. there has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Brian. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Brian's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those.
Yeah, they haven't told her where. They told her where, but she hasn't been able to look. Did she just say something about the alibi and they're still waiting on a date to discuss the alibi?
I didn't fully understand.
Let me turn. Let me turn the closed captioning on for a minute. I'm going to see exactly what she states about this alibi.
This before. We've had bits and pieces of tips, and they've come in and we've reviewed them. But the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us. But they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Brian. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Brian's our priority, but we are not going to be ready in June of 2024.
Okay, it's coming up.
Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need.
Oh, so is that why they never had a response by a deadline that they supposedly needed to have it by? Not that. Yeah. Interesting. Yeah, they never gave it. Yeah, because they wanted to meet with the judge without the prosecution. The whole ex parte.
I suppose it's also just coming down to they need more. There's something that they need.
Yeah.
Yeah.
What else? What else would you? I guess they need what? Well, okay, because maybe they need more from the. Maybe they need more from the prosecution because with the information that they have from Brian's own devices and the expert that they have going through that information, they're saying that he wasn't there, and they can give an example of why, which is why they wanted to meet with the judge. They didn't want the prosecution to see what evidence they had when it came to.
Yeah, I mean, they need to be able to respond to certain reports and stuff like that, right? So they need to actually have the whole thing in front of them before their experts can say anything. Otherwise, they're working on incomplete.
Yeah. So here we thought that she just didn't respond, but what she's saying is we didn't need to respond because there was no communication as to, I don't know, that's something.
So they can carve out a deadline as well. So,
yeah, like there wasn't a deadline. That's interesting. Let me go right back to that. We'll play it one more time.
Had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of
all the other
information we need. We need the cast report. We need other information of things that cast agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that.
Yeah, what they stated in the
I wanted
PCA.
to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions.
His phone.
I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Brian Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Brian Kohberger. I know different pieces, but I don't know where they fit together. And the more.
And this is Ann Taylor. So when we say we're reading the PCA and we have questions, everybody, they have more evidence. Yeah, so does Ann Taylor. Ann Taylor has way more evidence than we do.
Yeah, exactly.
So if Ann Taylor's saying the same thing that we're saying, come on, y'all. That's why I think a lot of us are coming to the conclusion, like, yeah, this is showing that they don't have. It's that Christmas stocking with crumpled up pieces of paper.
Yeah, and I mean, I think with the question of whether we have the whole PCA or whether the PCA is everything, I mean, that really does highlight that everything isn't everything, because one would assume she has a lot more. Well, she says she doesn't have everything she needs, but she has more than us, and she's confused. She says her team doesn't understand it either. And that seems to be like a theme, that's coming up. Like, you have a conclusion, but what was the pathway? Even just in terms of the vehicle, why exactly did you fixate on that one? Or with the DNA, yes, you have a match, but what was the root? Even the grand jury indictment, they can say stuff like, well, if it gets dismissed, we'll just default to the other option. It'll be the same outcome. The root still matters. How did you get there? Why did you choose that option if the other one was going to get you to the same place? You had to have a reason to do that. And I think that's something that's coming up a lot here. She's questioning the root, like the path.
Right.
Yeah.
Stuff that you claim that you already had in the PCA. Why, why, if you're so confident you have all this evidence, you would think that you would have it all put together, but it could be a tactic. We're just going to throw it all in there and you can do it. You do all the work that we did, which, they can do that. They could definitely do that.
Yeah. I think their main concern really is just the defense being able to retrace the steps. They just want them to focus on that final conclusion they've made, but the steps taken really matter, and I think she's highlighting that well.
She did a great job, and she's got all the evidence to defend that client. So, and that's her saying, look, the whole team, we've all gone through it for over a year, just like all of us here in these shows. We've gone through it for over a year. And she's saying the same thing as us, and she is privy to all of that information.
The more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So sure. I understand this. I mean, aware amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there.
That's sad.
I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Koberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
Nervous.
This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back.
Duh.
We can only predict
right.
the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips.
I'm going to pause that for a second, too, because that was another thing that was shocking to me is what if one of those 9,000 tips, you had to close down a tip line in order to get the residual tips? So what if one of those 9,000 tips made the difference in the case, but you couldn't do it until you shut it down? I don't understand.
Yeah, it just brings you back to why is there just this discrepancy where the one side is so ready, like they're counting down the minutes to start, and the other side is saying, we're not ready. Like, have they read all of those tips? I mean, he says he hasn't counted them, but has he read them?
Well, it's great. You're talking. So Ann Taylor stated a little bit ago that on 1/4/2024 they received the 9,000 tips, and that was after it went through its respective agencies that started in October of 2023. So it had to go to the FBI, ISP, MPD, prosecution, then Ann Taylor. So that's why it took from 10/23 to 1/24. But those 9,000 tips, when you shut it down in October of 2023, what if one of those that's like saying you have a 20 ounce of Mountain Dew and you can't dump out the remaining in the bottle unless you break the bottle open. I don't understand that. I really don't.
No, I I don't fully understand it either. I must be honest, but yeah, I think that we are starting to get a sort of a grasp on what they're up against on both sides. I mean, it's a lot. There's a lot to do.
It just what if one of those 9,000 tips was it? You got to close. So and when are you going to close the tip line? When you have all the information that you really probably don't need tips anymore. So it's like it's a contradiction. I need the tips to close the tip line, but I can't get the remaining tips until I close the tip line. Then why even use it? You know what I mean? Why even use it? It doesn't make sense. It's just something else that just was like, what?
Which are out there, but you're right. Most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, that there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here.
Hello.
Every doggone morning.
Boise.
I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere.
That's like when a little kid gets caught with his hand in a cookie jar and he goes, "But Mom, I was walking through the back door." Like, what are you talking about, bro? You're trying to argue how the case shouldn't be moved, but yet you're talking about how they're so invested already. Like, you're just giving. He just said it sounds like you're trying to argue for a change of venue, even though you're not arguing for a change of venue. And then he goes with more even infos. But Mommy, I swear I walked through the back door. When he's got chocolate on his lips, come on.
So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. And not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nespert.
Or you could go to the fucking Amazon rainforest, Bill Thompson. Come on, dude. Nobody heard about it there either, Bill. Like, come on, go to Boise. Jeez.
I mean, even South Africa, all over the country, people know.
You know what I mean? Come on, right? Oh, and then he's got Lewis. Where in the hell's that? Yeah, because they got like 22 people that live there. Something. Oh my gosh, it's great. Bill,
it's kind of small. Lodgings aren't very good as far as a lot of lodging. But
Right.
I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Lake Charles County.
Thank you, Mr. Thompson.
He's like, yeah, thank you. You just proved my.
So you're saying,
Proved it even
looking
more.
at this realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just
They don't need it in a timely fashion. They need the right person
Accuracy. Yeah.
convicted. Yes.
said a few minutes ago, that we only do this case once. That doesn't come back on appeal. That doesn't come back.
Measure, right, Kevin Kraft? Measure twice, cut once. Measure twice.
Or
cut
subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025. Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want a direct, certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but
you do take a long time to make a choice, though,
it's
Joe.
really hard for me right now to set something in 2025, even though that might be just the reality.
You still holding out hope.
And I know that there's lots of other issues to be addressed. I know there's going to be a lot of motions. There's going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge.
It's a good point, Cheryl.
So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life. It's hanging over your head. So, sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Thank you. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay. Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
All right, so there's that. If you want to have this for your own viewing pleasure, here's the link to the it's just the court hearing. I cut it out of the live from yesterday.
Yeah, I see
What a
the original
passive aggressive, you know?
passive aggressive. The judge or the state?
Yeah. Yeah, the judge. He just he does take a while to decide on things, but you know, I don't know. I just feel like I think this is the impression that I'm getting. And let me know what your impression is. The impression that I'm getting, and it's no fault of his own. The impression that I'm getting is that the experience just isn't there. He's afraid to make the wrong decision, to look like a fool. And he doesn't know what to decide at any moment because you got one side, which is the prosecution, saying that they're hurrying as much as they can. The defense is saying we need more that we should already have already. And so he's looking at it from both sides going, well, I'm telling the prosecution they need to hurry. It's not happening. That's why Ann has 11 supplemental requests for discovery. But at the same time, I have to look at, truth and justice, and the defense should be allowed to have all of this documentation that should be there. So he's kind of in a pickle, and then he's indecisive at the same time already, I think, naturally, because it just glorifies your character a little more,
I do think that he's sort of running the risk of making himself uninvolved by trying to appear very impartial. But I mean, he still does have a role to play in terms of actually, keeping the proceedings moving.
It is his court, yeah.
Yeah. I think sometimes I feel like he misses the point of what Ann Taylor is trying to say to him. Trying to explain the gravity of the situation she's up against, and he's kind of just saying, well, is there anything I can do to help? But yes, and also it's bigger than that, I think.
Right.
Yeah,
like really, I like the stuff that she should already have already if they were able to arrest him, and I think that's also why she's kind of going after the grand jury indictment too. When it comes to trying to get something happening, because they've been trying to have that grand jury indictment reversed for a while now. I'm thinking it's been since the summer, right? The fall, the beginning of fall, I think, something like that.
Yeah. So look, I suppose it's also coming down to that question of why that grand jury indictment was their preference or their choice. So I suppose that's also something she's trying to get to the bottom of. I don't know. I suppose we don't really know what she knows until they've made that decision on conceal stuff. But Judge is seeming notoriously slow and indecisive with his decisions. They speak about delays, but there's a part to play with everyone. I get he wants to make the right decision on everything that he does as well, but it just shows, the accuracy and contemplating things. It's going to take time for him as well.
Especially with the complexity of not only the crime, but everything that goes along with it and the new technology, whether it's cell phone or DNA. And when you look at, when it comes to why I think they did what they did when it came to the grand jury, because they already, I mean, Batanti even stated that there's exculpatory evidence to show that his client is innocent. And also, when they do the secret grand jury, the defense is not available. And everybody was asking earlier in chat, well, didn't they get? No, they didn't. They got transcripts. They got transcripts. That's what they were allowed to get, was transcripts. And so, I think they knew that they were, again, they were expecting evidence. In my opinion, they were expecting evidence to materialize in time. And during that grand jury, maybe enough of that evidence that they were expecting to materialize still wasn't there. And so they had to do that. Otherwise, maybe the case would have gotten tossed out. Because who knows what Ann Taylor would have done if she would have heard what the other grand jury members wanted to see as more evidence when it came to.
So, I mean, when they're saying in the beginning, we'll just default to another system and we'll get to the same outcome and the Supreme Court doesn't matter, is that true? Because, I mean, they made a choice to do it a certain way. So what was the reason? I mean, I don't come from a country where we have a jury, so I don't fully understand the system at all. So that's just, sort of an outsider's perspective on it. But I mean, there must have been some kind of an appeal to go that way. And I think that you're right about sort of keeping the defense at a distance as well, from what I understand.
Yeah, it'll be interesting. I'm sure there's going to be some documents coming soon, but I don't know how soon they'll be. I don't know. I'm just going to, it's what the prosecution has been saying for months. We gave them everything. I think they're going to continue to do that, because I think the more that the defense does get will show that's just more of what they don't have. I don't know. It's just how it seems to me.
I mean, in the beginning, they said the state did say they're making progress with things like to do with the IGG situation. So that would mean that they haven't given them everything if they're still making progress. So, yeah, still in progress.
It'll be interesting to see. So, yeah, and I'll reach out to you before I do my show tomorrow or any other show. I mean, you're more than welcome anytime you see me live and you hop in chat and you want to hop in, seriously, just let me know and I'll go ahead and drop you a link. And I really thank you for taking your time out today. And I'm so glad that you were able to join this evening. So thank you so much. And yes, if you're not subbed to True Crime Over Time with Rosie, please do. I'll be dropping the link. I'm going to do a contribution call out as I end the show, just to call out all the contributions one more time, since we were doing this special today. And we'll go ahead and be back tomorrow. I will be doing a show tomorrow night. I'm not sure exactly what the topic will be, but we will be covering something, and I'll be on tomorrow for the OJ 25 members only. Thank you so much, Rosie. Thank you for everything you do in the true crime community as well. Really, I appreciate it, and I know everybody out there does too. I hope you all have a peaceful and positive evening. Thank you so much. We'll see you 2 times tomorrow. Good night, everybody. Thank you, and good night, Rosie.
Bye.
Whoops. Good night.